Today we'll have to rise early, so we'll sit in the lunch break. So we'll try to finish off the matter by 2 o'clock. We'll sit till 2 o'clock. Kindly inform the other bar members also, okay? Nalai.
Lord, I beg to mention item number 35.
Yes.
Here, IO is filed. Can it be taken up next 20 days for other side?
35.
35.
What is the difficulty, Mr. Hawk?
My lord, I has been filed for injunction, and ad interim injunction has been passed. And we have filed.
That is your petition.
No, he is seeking vacation of that order.
Oh, you are seeking vacation. You are now seeking time.
Right.
Okay, if you are seeking time, no problem.
Yes.
Okay. 3. Mr. Hawk, your name is not there.
In particular.
Okay, you are in the main appeal. Okay, in the
Main
appropriate.
appeal.
3 N Hawk, learned counsel for the applicants. Pray for an accommodation. Full stop. 3 M. Datta, learned counsel for the opposite party appellant is present, who, however, submits that the interim order may be extended. Full stop. Para. When?
My lord, he has some problem before 26. Can it be on 28?
Next week?
No, next.
28, last day before the vacation.
He has some problem. I have no problem any day, my lord.
No, then it has to go beyond the vacation.
Can it be on 26, 25?
Or that week will be, you know what will happen that week.
So any date, my lord, the date may be.
No, you tell us, we'll fix a date, we'll have it on 17th July. Is it okay? As agreed to by the parties, list on 17th of July 2024. Para, interim order passed earlier to continue till the next date of listing.
May I please alert?
Yes,
I beg to mention item number 38, my lord.
38.
Matter may kindly be taken up before rising.
What is the matter about?
Madam, my lord, the execution proceeding is on last stage, my lord. Therefore,
IA has been filed.
I have
IA
been filed.
for?
My lord, no delay is there, my lord. My lord, I think that notice.
No, if the delay is yet to be condoned, can we
Yes.
pass any orders of injunction?
Yes, my lord.
Difficult. We'll consider. We'll have it. Don't worry. Other side has entered appearance for delay condonation.
No.
Then
Notice has not been issued, my lord, yet.
At best, we'll issue notice. What will you get? Okay, we'll have it.
Yes.
How many days delay?
My lord, there is the pendency before the wrong from is one of the plea, my lord. Therefore,
How many days?
561 days, my lord.
You do notice to issue code identity. Come for the first time.
Yes, my lord.
Or your image shall look there.
Yes, ma'am.
Three image shall look the learned counsel for the applicant who by means of this application filed under section 5 of the Limitation Act has prayed for condonation of delay, which has been stated to be 562 days. Stop. Para, let notice be issued. Returnable on 19th of July 2024. That steps be taken for service of notice upon the sole respondent. You take by registered post with AD, by registered post with AD. Steps within 3 working days. Okay. 26. Yes.
It is your lordship respondent to the expired. As honorable court has directed to us to provide the details of respondent number 2,
Yes.
but we have not the provided till now.
You are for whom?
So I'm on behalf of Philip.
Okay.
So lordship may kindly get the
One of your client has passed away. Respondent number 2.
yes.
Oh, he was not appearing for two, okay. On a prayer made by, your name?
Dilip Chaudhary.
Your name?
Janovi Dutta.
Miss J. Decca, Learned Counsel, appearing on instruction of Sri D. Chaudhary, Learned Counsel, submits a praise for and is granted 4 weeks further time to obtain instructions regarding the legal heirs of the respondent number 2,
Yes.
who has passed away in the meantime.
May you please, your lordship?
Yes.
Lordship, I beg to mention for listing of one MAC appeal, MSc appeal. It is a long pending matter. It has not been listed since
Appeal of which year?
2009.
2009.
It has not been listed since
Motor accident claims appeal.
after so many mentions have been made.
Okay,
it has-
we'll have it. Is it there? Is it still there in the records, or is it disposed of?
No. It's there.
It must have been disposed of by due to default or something. Have you checked it? Is it
Yes,
pending?
yes,
Okay,
yes,
we'll
yes.
have it. Next Thursday, next Wednesday.
Must of that.
Okay. Please give the date, madam. 19 morning. Okay.
I didn't want. May I please?
Yes.
Sir, transfer her proceeding from Guwahati Family Court to the District Judge Karimganj. Both the petitioner and respondents are permanent residents of Karimganj.
Petitioner is the wife.
Wife. He is having 2.5 years children.
Hmm?
He is having 2.5 years children also,
One child.
one child. And both are residents of Malik Karim. And in his petition also it reflects that the husband resides at Dubai. And sometimes Malay he resided here.
You
at
are staying at, where was the marriage?
Marriage at Karim. I have annexed the document. Marriage happened in,
You stay at Guwahati.
no, I have also stayed at Karim, wife.
Oh.
And husband also
You
stay
are
at
praying for
transfer of the proceeding from Guwahati, the
Oh,
family court
Guwahati to Karimganj.
Karim.
Okay. Why is it instituted in Guwahati?
I don't know, my lord, because he has stated that he stayed at Guwahati in some point of time when he was working at home. That it reflects in page 30 is in
Matrimonial home?
my at Karim.
Proceeding under for what?
Restoration of conjugal right he has, the husband has filed it.
So he must be having a house at Guwahati.
No, that doesn't, no house, my lord.
So
Is-
restitution of conjugal rights where? You must be living separately.
Yes.
Where you are living in Karimganj.
Yes.
Where is he living?
Now he's at Dubai.
That is okay. Presently at Dubai. But substantively, where is his residence?
At Karimganj. Permanent resident of Karim. And in some point of time, he stayed at Guwahati. That reflects in the petition.
Let us see. It's not very clear.
Page 30.
What is the restitution of conjugal rights?
My-
What is the meaning of restitution of conjugal rights?
They want to live together. my lord,
Minimum that you have to
that-
live together in the
Yes.
same, under the same roof.
Yes, yes,
So
that is
you need to have a residence at some place.
Yes.
You said that at times, he lives at Guwahati. Otherwise, he is a resident of
Resident of
Karimganj.
Karim.
You are also at Karimganj.
Right.
So restitution of conjugal rights where?
He wants, now he has at Dubai, now he wants to take back to in Guwahati, sorry, at Karim, Dubai.
Okay.
Right.
You
And-
are contesting the proceeding.
Yes.
Why you don't want to go to Dubai?
No, is a 498 proceeding is pending, my lord. I have annexed. the
Where?
At Karim. And doctors, my lord, the practitioners also reflect that husband tortured her. That it
Okay,
is-
heard. Sri and Hawk, Learned Counsel. For the petitioner who has filed this petition under section 24 of the Code of Civil Procedure, praying for transfer of FC civil case number so-and-so, pending in the court of the principal judge, family court at Guwahati, to the court of the learned district judge, Karimganj, full stop. The proceeding is for restitution of conjugal rights,
Right.
full stop, para. It is submitted that apart from the fact that the petitioner is residing at Karimganj, the marriage was also solemnized
Correct.
at Karimganj, and the respondent is also a resident
Okay.
of Karimganj, who, however, is presently staying at Dubai.
Dubai.
Full stop. It is submitted that for no reasons, comma, the proceeding has been instituted at Guwahati. Full stop, para. It is further submitted. Sri Hawk, the Learned Council submits that there is a 2.5-year-old child of the parties. And in the meantime, comma, the petitioner has also instituted a proceeding under section 498A of the IPC at Karimganj. Full stop, para. Let notice be issued returnable by 6 weeks. Let steps be taken for service of notice upon the sole respondent by registered post to DD. Steps within 3 working days. Let us see the restitution petition.
My lord, case 30, 29 start.
He is showing Paltan Bazar, Guwahati residence.
Okay.
Okay.
He is
Okay.
state.
Ah.
He had served a corporate job under different corporate sector in Guwahati. Both they are
No, but why haven't you given the Guwahati address in this petition? This will not be fair. In this
Well-
petition, the respondent has been shown to be of Karimganj. You have given only one address.
Well-
In the restitution case, which is a subject matter of challenge now or transfer now,
my
there he has shown that he is a resident of Guwahati. Aren't you required to serve at least in Guwahati? Additionally, you can serve at Karimganj. That's a different matter.
we can.
It's not proper presentation. Oh, para. It is sin that though the address of the respondent has been stated, has been put as Karimganj, comma, in the proceeding before the learned family court Guwahati, comma, his address is shown to be at Guwahati, full stop, para. Accordingly, steps are required to be taken. Now, accordingly, the learned counsel for the petitioner is required to file amended cost title incorporating both the addresses, and steps as directed above are to be required to be taken in both the addresses.
Both.
Para. Sri Hawk Learned Counsel prays for an interim order. Full stop, para. Considering the facts and circumstances, comma, till the next returnable date, comma, further proceedings in so and so shall remain suspended. Date at a diriba, or returnable 6 weeks course, returnable on 22nd of July.
Okay.
First, you give the amended cost title immediately, then you take
Well-
steps.
Today.
Next, if you're lost. I'm taking the transfer of a matrimonial suit my lord filed at Silchar. And the marriage took place at Guwahati. And the lady, they're having a boy of 10 years. And she has to go there.
Petitioner is the wife.
Yes,
Proceeding for
for divorce my lord.
instituted where?
She is a Guwahati man,
No, instituted at
Silchar. Marriage took place at Guwahati. He is a dealer in the scrap, railway scrap. He is often coming and going, my lord. And
marriage
he-
at Guwahati.
Yes, yes. I
You
stated that.
you are presently staying where?
Guwahati, my lord. Bhuttanagar.
You have a son
Yes, my
of
10 years, my lord. He is reading +5.
what do you do?
My lord, just no pension, no maintenance, nothing. Just teaching some student and earning 1,000 rupees per month, my lord. And my old parents are helping me.
You are having the from teaching you earn only 1,000.
1,000 students, my lord. I am a matric pass, my lord. I cannot earn more than that. HSC pass, only the KG students are thing and getting 1,000, my lord, and with that,
And how are you looking after yourself and the son?
my parents are looking after me. I stated that. In para, your lord will see, in para,
What are the grounds of divorce?
he says mental plurality. And I have filed a DB at my lord in Guwahati. I have stated, my lord, for maintenance. For last 1 year, he is not paying there because he's on and off and goes out from the Silchar.
Is there any order by the courts, magistrate for maintenance?
Notice was issued, my lord.
No order has been
No,
passed.
not. But notice was been issued.
Notice has been issued, but there
Yes.
is no order.
No
for
order was
maintenance.
that. So, my lord, I pray that that matter may be here, then both can be heard together. And it will be convenient for the husband also, my lord. For me, it is impossible to go there, my lord.
Why it will be convenient for the husband?
My lord,
Why will it be convenient for the husband?
because he is the scapegoat of the railway goods, my lord. Okay. So he often comes down, my lord. That is why the marriage took place at Guwahati, my
The business is at Guwahati
Guwahati.
or at Silchar?
Silchar or Guwahati, because he is doing with the railway scrap, my lord. So when there is an auction, he is to come.
If it was convenient for the husband, according to you, then
Yes.
he could have filed here. He has not filed here.
Where, my lord?
The
Yes,
plea-
he has been, that's why, my lord. He knows that there's no relative there. In fact, my lord, out of record, I say one thing, my lord, that the first thing they have filed up, I went there to make an understanding, and he forced me to sign a mutual divorce paper. And that was, I'm not aware, but just.
What
now
is
I
the stage?
matriculated.
What is the stage of the divorce?
My lord, just his notice has been received just now.
WS not filed.
No, my lord, nothing. My. That's why I'm paying.
What about the video conferencing facility?
My lord, video conference, she is only metric pass. She doesn't have such an idea also, my lord.
For video conferencing, you don't need to be a PhD.
No, not necessary, but she has to be bit learned,
Somebody will
my lord.
felicitate you. You just need to be there and express your.
No, my lord, that she has to be well acquainted, my lord. She is only a metric pass. I talked to her, my lord.
Things have changed, Mr. Bhattacharya.
Yes, our situation has changed. I understand, my. But
10
back
years
when-
back, there was no concept of plastic
lord,
money. Nowadays, even the rickshawala is having a plastic money, a
Yes, yes,
card,
that I agree, my lord.
a QR code.
My lord, that I agree, my lord. Because when there's every chance, my lord, I oppose the divorce, my lord. So there is, if he comes, my lord, that may be settled here.
Heard Sri K. Bhattacharya Learned Counsel for the petitioner who has filed this present petition. It's come for the first time.
Yes.
Why have you marked the with red pencil in the certified copy?
My lord, I don't know, my lord. I mistake it maybe by the clerk, my lord.
No, why by pencil red? Rico? In this copy, why do you touch this copy?
Oh, my mistake, my copy was given to your lord.
But that is the certified copy.
Yes, my lord. It is just because that is the notice, my lord, that I have received. So while he has the next line, instead he
That
should
is
have given the
certified, that is the-
photocopy, my lord. Instead of he should have given the original copy was the next. Sorry.
Under section 24 of this Act, for transfer of students, post title asylum. The petitioner is the wife and the proceeding in subject is for divorce, which has been instituted at Silchar, full stop. It is submitted that the marriage was at Guwahati and the petitioner is having, and the parties are having a son of 10 years who is staying with the petitioner at Guwahati, full stop. It is also submitted that the petitioner has instituted a proceeding under the Domestic Violence Act
Yes,
at Guwahati, which is being contested by the respondent, full stop para. Issue notice, same date, huh? Ki date asil ki month ago? Returnable. Returnable ki date asil? 19th July. 22nd July. Okay. Okay, 22nd July.
my lord, about the pendency, my lord,
Yes,
proceedings.
yes. You take steps within 3 working days
Well,
by registered post with AD.
apply.
Interim. Same. Aliyata Lishiba, the interim order would be reconsidered on the appearance of the writ at Lishiba. Wait. Yes,
Yeah, please.
item number?
Please. It is upon IM for injunction.
Yes, what is this?
My lord, the petition paper lordship is the plaintiff, my lord.
Hmm?
Petitioner paper lordship is the plaintiff.
Yes,
And my-
okay,
my-
okay, just a minute.
And my lord, my prayer for injunction was rejected, my lord.
Petitioner is the plaintiff.
Yes, my lord.
Suit for?
Suit for my lord, declaration of right, title, and my lord, possession.
Recovery,
No, my lord.
confirmation,
No, my lord, right and possession, my lord.
confirmation of possession.
No, my lord, he is dispossessed from the suit land.
Oh, then
And
recovery.
as well for recovery.
Okay, then you
Then,
had
my
an injunction application.
Yes, my lord. Initially, identity injunction was granted, but after hearing both the parties, my lord, injunction was rejected mainly on the ground that the petitioner has failed to prove that he was possessing the land at any point of time, my lord. And my lord,
What was the nature of the injunction?
my lord, to restrain the defendants from entering into the suit land and from making
Actually,
any.
you are asking for recovery.
Yes, my lord. And my lord, they are constructing, my lord. They are constructing.
That's a
one
different matter.
They are constructing one building.
That's a different matter. Not changing the
Yes.
feature and character of the suit land. That's a different matter. But you are asking for restraining them from entering.
Yes, my lord. And also for making any further construction.
Where is the prayer?
My lord, the injunction application is at page 35, my lord. Sorry, my lord, it starts from,
Page? Page?
my lord, it starts from page 27,
Yes.
and my lord, there in the injunction application is at page 30, my lord, 30 and 31.
Um, Thereafter, you had filed appeal.
Yes, my lord.
Appeal is-
Appeal also
Rejected.
dismissed. my lord.
Appeal rejected.
Yes, yes. Mainly on the ground that this plaintiff has failed to prove his possession, my lord. And my lord, that court, appellate court has also taken into consideration that since this is a society, so my lord, the 3 years have not completed, they have not submitted all the documents, name of the members and all this. But my lord, with regard to possession, my lord, they have this plaintiff has applied for settlement, and my lord, there is one report from the mandal that is at page 24. My
Let us see the impugned order of the appellate court.
lord, the appellate court starts from page 58 and relevant will be page 68, para 16, my lord.
You had earlier come before this court.
Yes, my lord, what happened during the pendency of the appeal, my lord? Neither my injunction application was disposed of, nor my lord, the appeal was disposed of. So that's why I have approached this court, and this honorable court directed the appeal to be.
So there was a status quo almost till the disposal of the
till the
appeal.
disposal of appeal.
Okay.
My lord,
Just a minute, please. 21A 23 was the rejection on contest.
Yes, my lord, by the trial court, my lord,
Yes, 21A 23.
by the trial.
Civil court, civil judge,
Civil judge junior.
junior division.
Division. Sir.
And High Court's order is 10-1.
10.
24 in
CRP
CRP
IO number 15 of 2020.
15 of 2024, you maintain status quo till the disposal of the appeal. And now appeal has been disposed of, rejected.
Rejected.
Page
My lord, it starts from page 58.
58.
5 and 11 will be page 68.
Uh, 21 to 24.
24.
First. Yes, what is there?
Page 68.
There are 50.
Page
68.
68.
Yes.
Yes, please.
There are 15 I'm reading. My lord.
Yes.
From the discussion made herein above, it is made out that appellants have failed to establish their contention that they were in possession of Schedule A late, identified them by them, hence no prima facie case to grant temporary injunction is in favor of the appellant. The observation made herein above reveals that the learned civil judge junior division was number 1 in passing the impugn order dated 25/5/2022. In which the case number so and so appreciated the materials on record available at that time, discussed all the three golden principles and accordingly rejected the prayer of temporary injunction. As the appellant could not establish their positions over Schedule A and identified by them, balance of convenience is also not in their favor to grant temporary injunction as prayed for. On failure on part of the appellant to establish their position over Schedule A and
Mr.
identify.
Gupta, you know the limitation of a revisional court that to confirm by in an appeal,
Yes,
matters of injunction,
yes.
it's a matter of discretion.
But my lord, this finding is perverse, my lord, because my lord, there is Mandal report which says that this plaintiffs are in possession. of
Will
the
you
true
go
title.
into those aspects by a revision court?
But the court has not considered this aspect, my lord. They,
We examine on a prima facie satisfaction, the appellate order as well as the trial court's order are containing reasons which are acceptable, plausible. Do you substitute the reason in revision?
No.
Madam, you are for whom?
I am for the deputy commissioner.
Deputy Commissioner Circle.
Okay.
Yes,
Or state respondents.
State-
Yes, sir. And it's the government effort.
My lord, government line and my lord, application for settlement is pending.
By that,
My lord, only for a moment, my lord, page 24, my lord, that is the report of the Mandal. My lord.
We'll dispose, will not, but we'll make an observation that any uh, uh, constructions or any activity will be subject to the outcome of the suit. More than that, you expect nothing.
My lord, only for a moment, page 24, my lord. My lord, it clearly
No,
shows
no.
that they were the
No,
plaintiffs
you are
were
not in
possessed-
possession. If they want to construct anything, they will construct at their own risk and cost. If tomorrow you are successful, you get the land along with the building. Free of cost.
So this is a,
And ensure that the quality of building is good. It
Well,
might come to you
my lord,
tomorrow.
the building was constructed by the government, my lord.
Very good. You'll get it tomorrow. Concentrate on the suit.
But there are two lands, Schedule A and Schedule B. They are saying that they are constructing on Schedule B land.
Not a fit case. Revisional jurisdiction, you know. And how do you overcome the last proviso? In 115, if the order was passed in your favor, would it bring an end to the proceeding? Apart from the three clauses of exercise of jurisdiction not conferred by law, not exercising jurisdiction conferred by law, material irregularity, there is also a last insertion by the amendment. If the order which is the subject matter of revision was passed in favor of you, that would have brought an end to the proceeding. Limited. And you have structured your petition under 115, not under 227. Today, that is also difficult. Virudnagar is very clear. If There is a remedy in the code. You cannot take recourse to 227.
My lord, the order is apparently perverse, but that is better.
Heard Sri A.K. Gupta, learned counsel for the petitioner who by means of this petition filed under section 115, read with section 151 of the Code of Civil Procedure, has put to challenge an order dated 21/2/2024 passed by the learned civil judge, senior division, Sipsagar, in so and so, এরপর লিখে দেবো post title. Para. Also heard Ms. D. Das Burman, learned state counsel,
Respond number 3 and 4.
who appears for the response numbers 3 and 4, full stop. Para. Considering the nature of the order proposed to be passed, comma, notices upon the other respondents is deemed to be not necessary. Para. The petitioner was the plaintiff in a suit instituted for declaration of right title and for confirmation of possession. Full stop. The said suit was registered as title suit number 26 of 2023 before the learned civil judge, junior division Sipsagar, and along with the said suit, comma, an application for injunction was filed, which was registered as Miss J case number 87 of 2023, full stop. Para. Though ex-parte ad interim injunction was initially granted, comma, the said application, said Miss case was dismissed on 21/8/2023 upon hearing the contesting parties. Full stop. The rejection order was the subject matter of an appeal before the learned court of civil judge senior division,
Yes, Civil judge senior.
civil judge senior division, comma, Sipsagar, in Miss Appeal 8 of 2023, full stop. It also appears that since the prayer for injunction was refused, comma, the petitioner had earlier approached this court by filing CRP IO 15 of 2024, in which this court had passed an order dated 10/1/2024 directing maintenance of status quo till the disposal of the appeal. Full stop. Para. The appeal has subsequently been dismissed by the impugned order dated 21/1/2024, and accordingly the present petition has been filed. Full stop. Para. The learned counsel for the petitioner has submitted that the rejection of the prayer for injunction, which has been upheld by the appellate court, is not based on the materials on record. Full stop. He submits that the findings arrived at that the petitioner was never in possession of the suit land is perverse, as materials were placed before both the courts which were not appreciated. Full stop. Para. It is further submitted that taking advantage of the impugned order, comma, the respondents are making constructions over the plot of land, full stop, para. The powers to be exercised by this court as a revisional court is a power of supervision, wherein the primary outlook is to see whether the exercise of jurisdiction by the subordinate courts was within the ambit of law, full stop. The scope of interference by exercise of powers under section 115 of the CPC is circumscribed and only on the fulfillment of the conditions laid down in the said section wherein such powers can be exercised. Full stop. By the amendment of the year 1999, which came into effect in the year 2002, comma, a proviso has also been inserted whereby it has been laid down that such powers are not to be exercised except where the order, if was made in favor of the party applying for revision, would have finally disposed of the suit or the other proceeding. Full stop, para. This court is of the considered opinion that the present may not be a fit case for exercise of such powers, full stop. The petition accordingly is rejected, full stop. It is however observed that interest of justice would be secured. No, if it is, if this court in the interest of justice, however, observes that while there would be no restriction, comma, any activities made on the suit land would be subject to the final outcome in the final outcome of title suit number so and so.
Can it be, my lord, instead of activity, any construction?
Any activity oblique constructions.
Oblique.
Any construction है लिखी भाई activity नहीं लिखी activity oblique construction है.
Oblique.
Title suit to number 2 ऊपर did you? Yes.
Lordship, may kindly pass over the matter for time being.
Time being. Who's your senior?
K. Singha.
Okay. For some time, ask him to come.
Mr.
What is impugned, my lord, the lower court has first closed the right of the claimant, my lord, to file evidence, and then after one day, the right of my lord, evidence has been restored. And the doctor will kindly have page 25 on.
Petitioner is who? The
Petitioners are the, my lord, the owners of the vehicle.
no. You are the plaintiff,
No, I am the opposite party in the claim.
defendant
Yes.
in
This
the
is a
suit.
claim petition. Under MSC.
Oh,
It's an MSC.
okay, MSc.
Lord.
Petitioner, you are the opposite party.
Yes,
In an MSc case.
in MSC.
Yes.
Now on the, my lord,
You are the owners.
yes.
Owners and driver of the vehicle.
Owner of the, yes.
Owners and driver.
Owner and driver. My lord, the claimants will not file their evidence on 22/8/2023. Lord.
It is before which tribunal?
This is MSCP Phase 4.
What had happened? Yes,
my lord, the
they've instituted a claim.
they've instituted a claim, my lord. We have filed our joint WS, my lord, and on 22/8/2023, which is there at page 25, my lord, the claimants filed their evidence. TW1,
You filed your WS,
yes, we have filed joint written statement that we have also placed on record.
then claimant filed evidence.
Claimant filed evidence on 22/8/2023, my lord,
22/8/23.
2023.
Yes,
Now, my lord, on 26/9/2023, and subsequently on 2 other dates, my lord, they sought adjournment. They did not
claimant sought adjournment.
claimants sought adjournment. This the dates are, my lord, there, pages 26, 27, and 28. 26/9/2023, 31/10/2023,
31/10/2023.
Yes.
And
and on 5/1/2024.
3 dates,
3 dates.
they sought
They sought
adjournment.
adjournment. And on 5/1/2024, my lord, which is at page 28,
Last date.
they were given a last option. There was a
Yes.
peremptory order. And specifically, it was mentioned as the last chance. So the opportunity, the date was next fixed on 26/2/2024, my lord,
Fixing 26/2.
26/2/2024.
Yes,
And that order is at page 29, my lord.
yes.
And on that day, my lord, the learned MSCP closed the right of the claimants to file.
26/9.
20
26/2.
26/2/2024.
Page,
Page 29, my lord, Annexure 4,
rights closed.
right close. And the next date was fixed on 20th of March, 20/03/2024, my lord, for TWL.
20/03/2024. Okay.
Yes. Now, my lord, on,
These
the-
adjournments were sought for the cross-examination part,
yes.
production of the
No-
witnesses.
Neither the claimants nor any witness appeared to. for
But they had
the
filed their evidence.
They filed their.
Obviously, the adjournment was to
Was to
enable them
produce.
to come up to the tribunal for
Ye-
their cross-examination,
Cross-examination.
which they did not come.
Yes.
So
And-
that opportunity was closed, and the next date was fixed on 20th of March.
20th of March.
Correct.
On
Then
20th of March, my lord, we filed a petition for adjournment of the TW evidence,
DW.
TW. And on that day, my lord, the claimants filed simply Haziram. There was no petition, nothing filed.
Okay. Okay.
Now, my lord, on the very next day, my lord, 9/4/2024, the claimants came up with a petition, which is at page 32, Annexure 6,
Yes, 30.
page 32, the estimate part.
Yes.
So this petition was filed without mentioning any reason, any provision of law, nothing was mentioned. So if I may just read for a minute.
Yes, yes.
উক্ত গোচৰৰ দাবীদাৰৰ বিনীত নিবেদন এই যে যোৱা ধাৰ্য 26/2/24 তাৰিখে দাবীদাৰৰ অসুস্থতাৰ কাৰণে তেওঁ সাক্ষী লৈ মাননীয় আদালতত হাজিৰ হ'ব পৰা নাছিল। এই মাননীয় আদালতে দাবীদাৰৰ পক্ষৰ সাক্ষীৰ দিন সমাপ্ত কৰি অপৰ
Okay, this is an application for allowing them another opportunity.
allowing basically for recall of the earlier order.
Okay, okay.
Now, this petition, my lord, pursuant to this petition, the order dated at the same date, 9/4/2024, we were not allowed any opportunity to file any objection or anything, my lord. That is at page 30. And in fact, my lord, there.
But why, what is praying for to submit affidavit in evidence?
Yes, actually, what had happened, if your lordship sees the order at
Application.
page 25, what happened was that they, along with the evidence, filed some photocopies also. So they would have to file necessary section 65 Evidence Act petitions, my lord, for. So their part of the evidence, their submission of the documentary evidence was not complete. And thereafter, my lord, 5 dates went by, and on 9/4, when they filed the petition, so there it was not only a question of cross-examination, but also, my lord, to justify the secondary evidence. So a petition for secondary evidence would have to be filed. This was, my lord, recorded by the trial court, my lord, on 9/4/2024, when the trial court allowed the petition without issuing any notice or hearing any objection on our part. And, my lord, they were allowed at with a cost of ₹1,000. And
But the next date has been fixed for cross-examination.
yes,
It is
cross-examination,
not for allowing them to file any petition for secondary evidence.
that is up to them, my lord. They may file or they may not file.
No, it
No,
is
look-
for cross-examination.
Yes, the court is fixed, but they can come up because if your lordship comes, my lord, for a minute to page 25.
No, we do not know, but without the leave of the court, can they file an application? You see, you cannot restrain anybody from filing an application.
No, we can. I'm not on the
Any,
application part.
but whether this application is maintainable or not, that's a different matter.
Yeah.
Anybody can file an application, whether the consequences, we are not too much concerned now.
Okay.
But the court has fixed the next date for
Cross-examine.
cross-examination.
And if your lordship sees page 25 below, that
You
evidence
say
as
that
such-
their documents are not
Yes, that is-
properly.
that is there at page 25. The order of,
See, the entire objective of the claim, as you know, MSCT,
Good.
you don't apply the strict rules of technicalities.
even then, my lord,
No.
the
Now, what prejudice do you suffer?
I suffer, my lord, because my lord, I am the party who will have to pay the claim, my lord. That is the difficulty. And
see-
I was not allowed any opportunity to place my objection. I filed a petition, my lord, on the next
No,
day.
that's a different matter.
Yes, that petition, my lord, was summarily rejected.
Your vehicle was not insured.
Vehicle was not there. That is why, my lord, the prejudice part comes in. And my lord, on 16th May 2024, lordship will find at page 34, I filed this petition that I have not been heard at all. Because the petition was filed summarily without any ground, nothing, no documents. My lord, this,
Suppose we remand back, give you a hearing, and again the same order is passed, then
my lord, the learned trial
see,
court,
the apprehension which you are now expressing,
Gotcha.
that evidence has not been properly adduced, even in the chief. There are documents which are not originals.
I am not
you-
on that part, my lord.
You,
I am
you
on the
take
part
the
of juris-
advantage.
I am on the part of jurisdiction, whether the tribunal had the jurisdiction to recall its own order in the absence of the conditions precedent. my lord. There are coordinate bench judgments of this court under order 17. My lord, order 17 will apply because whether it is MSCT, it's a civil procedure guided by the CPC. There is no separate procedure as such under the principles of civil law will apply. My lord, order 17, my lords, once the
In the tribunal, the CPC will apply.
CPC will apply. CPC,
The
wherever, my lord,
strict rules of CPC will apply in a tribunal.
no, strict rules of evidence may not apply, my lord, but all the rules of CPC may not be applicable. But for first, my lord, the rules relating to appearance, witness, adjournment, they have to be they have to be applied.
We may not agree with that.
Otherwise, my
Let
lord,
us see what is that.
Yeah.
There are decisions only for particular action.
Look.
You take the powers, you can act as a civil court.
Yes.
For recall, for calling of witnesses,
Yes.
for summons, for discovery, all those.
Yes.
Nothing beyond that. Otherwise, it's
because otherwise, my lord, there is as such no bar also in application of the CPC.
which one are you?
My lords, I am first on, my lords, coordinate bench.
Bhatti High Court.
Yes,
Diputas.
yes.
Yes.
That's, my lord. If your lordship will have, my lord, the second page.
Yes.
This application was under Article 227 of the Constitution challenging the order dated so and so, whereby the evidence of the defendant which was closed, while an order dated so and so was sought to be recalled by the petitioner by way of an application under section 151 CPC was rejected. I have heard so and so. From the impugned order, it reflects that the defendant had failed to file his evidence on affidavit on 6 consecutive dates, and thereupon on 10/10/2013, the court below had closed the evidence of the defendant and fixed it for arguments. Thereupon, the petitioner filed an application after a period of 4 months on 18/2/2014 for recalling the said order dated 10/10/2013. The court below, taking into consideration the provisions of Order 17, Rule 1, and more particularly to the proviso that no adjournment shall be granted for more than 3 times to a party during the hearing of a suit, have rejected the said application filed for recalling of the order. At this stage, it may be relevant here to mention that when an application is filed under section 151 CPC for recalling of an order, same is permissible when the said order is sought to be recalled, has been obtained by fraud practiced upon the party, when the court is misled by a party, when the court itself commits a mistake which prejudices the party, or a judgment was rendered in ignorance of the fact that the necessary party had not been served at all or had died as the estate was not represented. The above proposition of law is well settled by the Supreme Court in the case of Budhia Swain, which also I have. Now, in the instant case, none of the
No,
above.
this was a matter of the MSCT.
No, this was not MSCT.
Then
Look, regardless of that, Lordship will conceive a
this
situation.
application is not filed under 151.
There is no provision, my lord, under which it has been filed. That is the part. my lord.
Why is it required that you're bound to mention a provision in a
My
tribunal?
lord, then the tribunal would have to have some some inherent power. My lord. That inherent power has to come from 151 CPC only. There is no other provision. The tribunal, the Motor Vehicles Act does not have prescribe any inherent power to recall. Let us conceive a situation, my lord, where at any stage of the case, my lord, they can file a recall application.
It
All
is not
the
at any stage. It's a claim of which year? It's not a case where indefinite adjournments have been taken, the process of law has been taken for a ride.
No, I'm
Some
not
three
saying that.
adjournment, they have filed the evidence, it's a
They-
motor accident
But
claim.
once
The
once their,
objective is benevolent, sorry,
once their
sorry,
right
Mr.
was,
Ganguly.
once their right was closed, my lord, they did not, they had the remedy before this court, my lord. They could have come, but they should not have, my lord, gone there and, my lord,
The tribunal has given them the relief, why should they come before this court?
my lord, tribunal has
Sorry,
wrongly, my lord,
Hearts
that-
V. A. Ganguly, learned counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India.
It may remand it back, my lord, for at least hearing me. I have not even been heard by the tribunal, my lord, but this is a default situation, my lord. My objection, I am, if I am not prejudiced, then, my lord, I have to even some sort of a reply, my lord. My objection was filed on the very next day. I was not given any notice.
You are now shifting your arguments.
No, my lord, in any, I
You
have to
have
be
said
heard,
that
my lord,
powers.
obviously. No, my lord, I'm not saying. There is a jurisdictional issue here. I have to be heard by the learned trial court.
That is not a jurisdiction, it's a procedural aspect.
My lord, the learned
Where
trial
is the
court has- learned trial court
jurisdictional
has
issue?
exceeded its jurisdiction, my lord. The power under 151 cannot be
That's a
exercised like.
procedural aspect, whether you give your hearing or in a matter of this kind,
Lordship.
where a claim has been raised on the basis because of an accident in an
I'm not on
MACT.
Merits, my lord. Lordship will only examine one aspect, my lord. The jurisdiction,
we
the-
don't
the
find, okay.
petition, the petition has to be under 151. I have not been heard. The order has been set aside.
So, okay.
My lords, that part, my lords, at least a hearing.
Revisional powers with 227 powers.
Yes, 227 power, my lord. Where is the jurisdiction of the trial court? That is what Dipu Das judgment is saying, my lord.
Dipu Das is in a civil proceeding.
My lord, this is also a civil proceeding, my lord.
This is before a tribunal, Mr. Ganguly. Show us any law that
Well,
the
the-
strict rules of CPC are applicable in a
my lord, the
tribunal.
principles
We'll,
would be-
we'll agree with
my
you.
lord, the tribunal does not have any inherent power apart from
It's not a
151.
question of inherent power. It's a question of exercising of powers for to secure the ends of justice.
My lord, the-
Nothing else.
The minimum that should
You
have-
don't leave a claimant high and dry like this. He was not able to produce himself for cross-examination for 3
Lord-
days. He has shown good reasons, allowed on cost. What else do you need?
my lord, no good reason is cited in the petition, my lord. Petition is silent.
Oh, who has filed this application under Article 227 of the Constitution of India against orders dated 9/4/2024 and 16/5/2024 passed by, and that to a death case.
Not here, we are not on merit. my lord. The
We
jurisdiction
are
of
on
the-
merits.
Lord,
You
we
cannot
consider-
preclude somebody from even having the matter entertained on merits
No,
in a death case.
They would,
Your vehicle is not insured, that's your headache.
that is
You
their-
cannot take the recourse of finities or technicalities of law, come to the High Court and frustrate somebody.
Because, my lord, the hearing, right of hearing has been denied to me. That is my main remark. I have
We are
not been-
not on those niceties.
But I, that's my case.
In MSc, the case number 92 of 2002, within bracket D, before the learned MACT, Sonitpur at Tejpur. Full stop, para. The projected case in this petition is that the para na. In view of the the projected case in the petition is that the respondents, please have your seat, Mr. Ganguly,
Sure.
had instituted the aforesaid claim before the tribunal, claiming compensation on the deaths of one Nur Islam alias Nur Islam in a motor vehicles accident, full stop. Full stop, in which the petitioners are made the opposite parties, full stop. The petitioners are the owner and driver of the vehicle in question, full stop. It is submitted, it is projected that the petitioners had filed a joint written statement, and on 22/8/2023, the claimants had filed the evidence, full stop. Thereafter, the matter had come up for consideration before the tribunal on 26/9/2023, and 31/10/2023, when adjournment was sought for by the claimants, full stop. When the matter had come up for consideration thereafter on 5/1/2024, a last opportunity was granted to the claimants, fixing the next date as 26/2/2024, full stop. On the next date, on the said date, i.e. 26/2/2024, the where is that order? 29. The
26 to
at page 29, I think.
20.
The claimant witness was closed and the next date was fixed on 23/2024. Full stop. Para. On 23/2024, the petitioners had filed an application seeking adjournment for filing of DWs. And on the said date, the opposite party, the respondents claimants had filed Hazira. Full stop. However, on 9/4/2024, an application was filed by the respondent claimants, which appears to be an application for recall of the earlier direction of the tribunal and to allow the cross-examination of the claimant witness, full stop. Wide the impugned order dated 9/4/2024, the said petition was allowed with cost of rupees 10,000 payable to the DLSA Sonitpur, full stop. On the said date, it appears that the petition filed by the present petitioners for adjournment for DW was also allowed, full stop. The tribunal had fixed the next date as 16/5/2024 for cross-examination, full stop. Para. Sri Ganguly, the learned counsel for the petitioners, has submitted that the aforesaid order, that the impugned order suffers from jurisdictional error inasmuch as the same was passed without hearing, without there being any inherent powers of the tribunal to
Section 169 of the MP Act also makes my submission. 160.
to recall any such order, MV, Motor Vehicles Act, full stop. It is submitted that the power, that the petition has to be construed to be a petition under Section 151 of the CPC, and such powers cannot be exercised by taking recourse to the aforesaid provision of law, full stop. The learned counsel has also referred to Section 169 of the Motor Vehicles Act, which lays down the procedure and powers of the claims tribunal, full stop. Para. It is further submitted that the impugned order was passed without giving any opportunity to the petitioners to file any objection, full stop. It is submitted that while the order dated 26/2/2024, a substantive right had accrued upon the petitioners who were contesting the claim, and that right could not have been taken away without giving any opportunity. Full stop. Para. The learned counsel, in support of his submission, has relied upon an order dated 3/12/2021 passed by this court in CRP 157 of 2014, Dipudas versus so-and-so, which, full stop, this court in the aforesaid order had also relied upon the judgment of the Honorable Supreme Court reported in 1999 to SCR.
Lordship, please otherwise 1999 4 SCC 396.
We have SCC.
I have
1999?
the SCR.
No, we have SCC submission you have? SCC citation, 1999?
No,
To SCR, I think.
but it is aging in SCR. 1999 to SCR.
Yes, 1189,
Yes, 11.
1999 to SCR, আমি পাৰিলে এইটো SCC report, 1189, full stop. Para. So Ganguly, the learned counsel accordingly submits that the interference is to be made by this court against the impugned order. Full stop. Para. The order impugned in this proceeding filed under Article 227 of the Constitution of India is passed by a tribunal, by a motor accident tribunal in a death case. Full stop. The claim was instituted in the year 2022, and it appears that the claimants have already filed the evidence on affidavit. Full stop. Though it appears that 3 numbers of adjournments were sought for production of the CWs for their cross-examination, whereafter the order dated 26/2/2024 was passed, closing the CWs, the respondent claimants had filed an application on 9/4/2024 for which is effectively for recall of the earlier order and for acceptance of the claimant's evidence. Full stop. Para. The learned tribunal, by the impugned order dated 9/4/2024, had allowed the said petition on cost, and there is a specific direction while fixing the next date that it would be only for cross-examination. Full stop. The aforesaid order had also allowed the petition of the present petitioners for adjournment for filing of the DWs. Full stop. Para. The tribunal exercising powers under the Motor Vehicles Act 1988 and the rules framed thereunder is not bound by the strict rules of the Code of Civil Procedure. Full stop. The reference to section 169 of the Act would itself make it clear that it is only for certain purposes that the tribunal would be deemed to be a civil court, and those purposes have been specifically mentioned to be section 195, to be, have been specifically mentioned in section 169 within bracket 2 of the Act, full stop. The reliance upon the order of this court in Dipuda Supra and also of the Honorable Supreme Court in Budhia Swine Supra are orders which were passed qua the exercise of powers by a civil court in under section 151 of the CPC. Full stop. Para. Though the order dated 9/4/2024 appears to have been passed on the same date when the application was made by the respondent claimants, and apparently the present petitioners were not given an effective opportunity, this court is of the considered opinion that the powers exercised by the tribunal was only to secure the ends of justice, as the entire objective of the motor accident of the codification of the Motor Accidents Act 1988 and the rules is a beneficial legislation whereby the tortious liability of that nature has been codified in a structured in a manner whereby such claims can be easily disposed of. Full stop. Para. The powers to be exercised by this court under Article 227 is a power of superintendence, wherein this court is only to look out whether the orders passed by the subordinate court / tribunal was within the ambit of law. Full stop. In the considered opinion of this court, the impugned order does not appear to be one which calls for any interference by this court. Petition accordingly stands dismissed.
Okay, next.
Item 45 subpoenas.
Don't believe awesome. Yes, Mr. Rajan.
May it please, Lord. My Lord, in a suit for division of share and partition, I filed an application praying for my impleasment as a successor interest and co-sharer. My
This
Lord.
is item number.
Item number 45.
Petitioner is the
My
Plaintiff.
petitioner is the son of.
plaintiff. You are the
No,
plaintiff.
my Lord, I am the son of the proper defendant number 27.
Number 27.
Lordship. Suit, my Lord,
Suit for?
Suit for, my Lord, division of share and for partition of the properties,
Okay, suit for partition.
partition. My Lord, suit proceeded ex-parte for, against defendant number 5 to 38. And defendant number 1 to 4 filed a written statement.
Oh,
And defendant number 39 to 43 also filed written statement.
39 to?
43. They are all perform. Main
Yes.
defendants 1 to 4. My mother was made proper defendant number 27. My Lord, in the suit, the address, the name of my mother and the address was very incorrectly given. Therefore, notice was shown to have been served to my mother's brother, who in fact the process server report is there, my Lord, who says the notice is served on the brother of my mother, brother of the defendant number 27. Brother is defendant number 28. and from the plaint itself, it will show that defendant number 28 is not my brother. Process server report says served on his own brother, and the plaint itself will show that they say fathers are different, is not my own brother. Therefore, my mother did not
This person who had received notice on behalf of your mother, is the defendant number 28.
28. He is also against him also suit proceeded ex-parte.
Okay.
And two others. Defendant number he received on behalf of defendant number 20, 25, 26, and 27. Two others. The report says that I was not present in the place.
Your mother was not present.
A mother was not present. It is specifically stated. Now, my lord, my mother died in 2019, 18. Then I, my lord, filed an application praying for getting me implemented in the suit.
Substituted.
Substituted. In fact, I filed showing a wrong provision of law. The trial court said I ought to have filed an application under order on Rule 10(2), but I filed it on Order 1 Rule 8A and Order 9 Rule 7 because the suit proceeded ex-parte against my mother. So I wanted that order, that ex-parte order to satisfy, recall, and then get me implemented in the suit. That was the idea, perhaps, of the petitioner. But then
You did not file for substitution.
I have not filed because
You filed for inclusion of your name.
I did not file with
But
perhaps
your rights are accrued only on the death of your mother.
on the death, right? My lord,
So
in fact,
you'd be substituted.
I could have,
Yes.
but perhaps, my lord, because my the suit against my mother went ex-parte. I would step into shoes of my mother. Well, I cannot file my own defense here. Therefore, my lord, I filed an application praying for recalling of that ex-parte order. But the notice was not served. The trial court, my lord, quite mechanically,
You filed two applications.
one application
Under
under Order 1 Rule 8A, that was the wrong provision of law. Praying.
8A.
I can admit, my lord.
Okay. And the other one, rule?
Other Order 9 Rule 7.
Red with?
Read with 151.
No, you had filed one application.
One application,
Order 1 Rule 8A.
Order 1 Rule 8A, read with Order 9 Rule 7, and read with 151.
That is read with
Read with Order 9 Rule 7,
Rule 7.
and read with 151. My lord, apparently, my lord, provisions were not, but Supreme Court, my lord, in a partition suit, the lordship is aware, that everybody, my lord,
But
forced-
9-7, how will it lie by you? You are a stranger to the proceeding.
It ought to be, because my mother did not know. My
No,
mother,
no, you have a procedure which you know
my lord,
what to adopt.
lordship,
How do you come into the picture,
Lordship,
enter
lordship.
into the room, then
Quite
you make
right.
your submission?
Quite
So
right.
we are not even given an entrance to the room. How can you make a submission?
That's right, my lord. In fact, that's why, my lord, I ought to have filed an application on the Order 1 Rule 8, Order 1 Rule 10, for getting me.
That is also one of the procedure which you could have
But the
adopted.
Supreme Court says, my lord, even Order 1 Rule 10(2) is not applicable, is not right. In any case, Supreme Court has stated. But this lordship is aware, relying on Shagram Singh, the Supreme Court in later decision in partition suit said the court should not go so technical. Maybe a wrong provision is so, roads should not go so technical.
No, we are not on the provision of law which you are citing while
Lordship.
making an application. But at the same time, you cannot forego. What is the objective
Order
of
20
having so many orders and so many rules?
No, lordship is absolutely right. I ought to have, Order 22 Rule 4 is there, my lord.
We are not
And
on the wrong quoting or not quoting. But what is the substantive relief you are seeking by the application?
is implemented.
Is implement.
Implement. So the court, even the court can, my lord,
Okay, then what had happened?
my lord, the trial court, the lordship has held, firstly, that I ought to have filed Order 1 Rule 10,
Okay,
that's
okay.
one.
Which
Secondly,
order dated?
my lord,
Order dated?
trial court's order dated 10/5/2020,
10-5,
2020,
24.
24,
Page?
page 76.
Okay, what happened?
Now, my lord, trial court has held that the process server's report shows the notice is shown to have been served to the mother, to the brother of my mother. Therefore, that it is a presumption that I have received the right note. That's not wrong, because lordship will kindly have a look at page. Lordship will kindly have a look.
This observation, Mr. Rajchodri, this observation is on your petition
Yes. In my petition,
and it is rejected or what?
reject. That against that I have come for. I wanted impleadment because I am a co-sharer. And it is an admitted position, my lord, in the plain that my predecessor
Are
interest,
you precluded from filing a substitution application?
my lord,
Are you precluded from filing a substitution application?
no, my lord, I could have
You
filed.
want a right to be
My mother
represented,
died
you want
long
a
back.
right to be heard. You get yourself impleaded
My
by way
lord
of
is right,
substitution.
my lord, because what plaintiff did, he, my lord, got the
You
student,
have got other siblings.
my lord.
Have you got other siblings?
No, I'm the only son. I'm the only son
Of the mother
of the mother,
of 27.
27. Now, my lord, I cannot take because the suit is in my name because there is already a documents, my lord. But in the plaintiff said that my predecessor interest sold the
now-
land to. Therefore, my lord, I had to file.
No, Mr. Roy, there is one more thing.
Lordship.
Suppose one of the defendant, maybe ex-parte, the defendant has passed away in the meantime. The duty is cast upon whom?
Plaintiff.
Plaintiff.
He did not
The-
do that.
Exact. That is the,
That's the
it is the duty of the plaintiff.
plaintiff.
to-
Though it is ex-parte, because
No.
I'm still a part.
That is it. If it is the duty of the plaintiff which has fallen from you,
Lordship.
we are extracting that.
Lord.
The plaintiff has not discharged his duties to file application for substitution.
Therefore, my lord,
You need not come in. That I not, you need not come in on your own, that implead me as a party. I am the legal heir of a party who was the defendant, passed away. It's the duty of the plaintiff, unless he impleads you,
absolutely. I have taken
then
this plea.
he will suffer the prejudice.
I have taken the
You
plea.
have got nothing to lose.
Now, my lord, I wanted to get myself implead because the plaintiff has stated a wrong thing, he was obtained a wrong decree. Because he said that my predecessor interest sold the properties in dark nature,
No,
Maida.
no, Mr. Roy, those are on the merits of the case.
That's it.
We are not on the merits.
Therefore, my lord,
Let us assume everything what you have said to be correct. The acceptance of the notice by defendant number 28 stating himself to be the brother is not correct. He is not the brother. In fact, the person who had received notice, he is also a defendant in the suit.
yeah, he expected.
Defendant he also passed away.
Eh.
Your mother, defendant number 27, has passed away.
Hmm.
On your own, you tried to get yourself impleaded. You gave a wrong provision. That's a different matter. Matter rejected. Now, can the suit proceed in your absence or in the absence of the legal heir of one of the defendant who has passed away?
It cannot.
Then
Therefore, my lord, it cannot because
you had made an endeavor
my
that
lord,
I am the legal heir. I want to get myself impleaded, rejected. And later on, you have shown more than what is required to show your bona fide.
my lord, I have come against the order of rejection, my lord. Because that's because in a partition suit, my lord, the Supreme Court having said every co-sharer ought to be a party because how the decree will be executed. Because in a partition suit, the plaintiff must show that he is the title holder of that property. Sought to be
Your right has germinated on the death of your mother or prior to death.
But
Tell us.
my after the
After the mother. Though you'll be substituted if he doesn't file an application for substitution. Sit tight. Enjoy the show.
No, my lord. Then after the decree would be passed
How can a decree be passed
against
without
because,
substitution if there's a legal error? You have already shown that you are a legal error.
because the suit there is an order ex-parte against my mother.
Ex-parte or inter parte?
If I no, my lord, if
Ex-parte or inter parte, partition suit, you may contest, you may choose not to contest. That will not make or take away the requirement of law to substitute a defendant who has passed away.
But if I am impleaded, my lord, if I file an application under order 22 rule 4, my lord, what will be
No,
my
Mr. Roy, we are not against your for adjudication of the matter before us.
lordship?
We are only thinking on a broader perspective.
The lordship is right.
That whether you needed to even make an endeavor to the court to implead yourself. Was it necessary?
Because the court will let us say, my lord, when you knew, why did you not? I will not get you.
Where is the law?
No, my lord. Because I
You
already,
have said it is the duty of the
No, but
of the plaintiff who has come to the court plaintiff or appellant or
And
petitioner that
There
wants.
may be, I had a remedy. Why did I not take the remedy in a higher court? Therefore, not
No, you did not, you were not to take any remedy. Somebody has passed away, let them, it's their duty, their obligation to file substitution application.
in
Where
fact,
is that order? 76.
my lord, it is page 76.
What is the stage of the suit now?
Suit, my lord,
Suit is of the year, which year?
argument stage. But then,
2012.
my lord, it happened like that. Suit is an argument stage. I admit it. But now the last order, the defendant number, the advocate for the defendant number 1349 retired. So fresh notice has been start on them. So it will go again.
Hearts Free Piquet Alliance Senior Counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India, challenging an order dated 10/5/2024, passed by the learned civil judge, Senior Division Number 2, Silchar, in Ms. J case number 24 of 2020,
Because
arising out of title suit number 16 of 2012. Full stop. Para. The projected case is that the mother of the present petitioner, please have your seat,
Sure.
was arraigned as pro forma defendant number 27 in the aforesaid suit filed for partition. Full stop. The service of notice upon his mother is one of the issues which has been raised. Full stop. The suit has proceeded ex parte against the mother, who however had passed away in the year 2018.
2000,
18 you had said?
no, my lord, it's 19, 10/6/2019.
You
huh?
said 18,
Oh, no, my lord, 19/12/2015.
15, you had said 18 at that
I'm
time.
sorry.
The-
Yes, that is-
2015,
Lord,
2015, full stop. Para. No, para no, actually. Accordingly, the petitioner had filed an application under Order 1, Rule 8, within bracket A, read with Order 9, Rule 7, read with Section 151 of the CPC, which was registered as Ms. J case number 24 of 2020. Full stop. Para. Para na lage actually. By the impugned order, comma, impugned order dated 10/5/2024, comma, the aforesaid petition has been rejected. Full stop. Para. The London Senior Council has submitted that the provisions of law, provisions of the code, COD, under which the petition was filed may not be correct. Full stop. However, the substantive relief which was sought for was only to give a fair opportunity to the petitioner and for proper adjudication of the lease before the learned court. Full stop. It is submitted that without appreciating the aforesaid aspects, comma, the impugned order has been passed. Full stop. Para. Let notice be issued, returnable on July 19th, 2024. Let steps be taken for service of notice upon the respondents by registered post with AD. Steps within 3 working days. Full stop. Para. The suit is of the year 2012 and is stated to be at the stage of arguments. Full stop. However, due to retirement of certain counsel, comma, notices have been sent. Full stop. Para. Under those circumstances, comma, the hearing the consideration on the interim prayer is deferred to the next returnable date. You serve
Huh? My lord, next date is 8/7, my lord.
8/7 is for notice of
Lordship.
council.
But till then, my lord, till then.
No, we are not saying. You come, then we'll see. We have not declined.
My lord, your lordship has given the 19th, my lord.
19th, you can
Let it
give
be-
any other
let it be
date
2 or 3 days later, my lord, or
on 22nd.
22nd.
19th is a Friday. We'll have it on Monday, then 22nd.
Lord.
Okay. Again, for time being.
My lord, this is against the order of my lord, the learned trial court, whereby the my lord PW evidence has been declared as expunged, my lord, because non-appearance of the PWs before the my lord advocate commissioner.
Petitioner is what? Defendant.
Plaintiff, my lord,
Petitioner plaintiff.
my lord.
Suit for
Good for my lord, right title interest and for and permanent injunction, my lord.
declaration, right title, interest.
And-
permanent injunction.
Yes, recovery of possession and.
Recovery
permanent-
also.
Yes, my lord, recovery is there. Because the lane is, good lane is, my lord, in the possession.
Okay,
of the
then what had happened?
My lord, then, my lord, the defendant appeared and filed a WS,
Oh, WS filed.
file, my lord. And
How many defendants?
my lord, 6 defendants are there, my lord. Six-
They have
eight-
filed, they have filed jointly.
Yes, my lord.
Okay. Then
Then subsequently, my lord, PW has been filed.
You-
Evidence of the plaintiff has been filed, my
how
lord.
many?
My lord, PW,
You would
1
file
to 4, my lord.
1 to 4, file affidavit on evidence.
Yes, my lord. Then, my lord, the trial court, my lord, fixed the matter for evidence and forwarded the matter to the advocate commissioner, my lord,
For
for
cross-examination.
cross-examination. Fixing a date, my lord, on that day, my lord, fixed for cross-examination, my lord. The engaged counsel of the plaintiff, my lord. could not-
Just a minute. Which date was fixed?
My lord, 25/1/19,
25/1/19,
my lord,
2019.
my lord.
Yes.
There, my lord, on that day,
এইটো কৰি পেলাই উঠিম, এইটো হে কৰকচোন।
my lord, on that day, the engaged counsel of the plaintiff, my lord, could not make any contact with the commissioner, my lord.
Oh.
So they, on that day, my lord, no cross-examination was done.
Did you appear?
My lord,
Did you appear?
the trial court.
No, did you appear? Did the plaintiff appear for their
No, my lord,
cross-exam-
they could not make any contact with the my lord, learned advocate commissioner.
Advocate did not inform the date.
Yes,
None of the plaintiff witness could appear.
my lord, could appear, my lord. And my lord, on 14/3, my lord, of 19, the learned, my lord, advocate commissioner, my lord, submitted a report for non-appearance of the plaintiff witness, my lord.
Mm.
Accordingly, my lord, on 14/3/19, the learned trial court, my lord, passed this order, my lord. Lordship may kindly see page 32.
32.
Annexure 3, my lord.
Yes.
Order dated, my lord, 14/3/19. Both
Hmm.
sides are represented. Seen the report of the commissioner stating that the plaintiff side has not made any contact with the commissioner and so cross-examination of PW could not be conducted. In view of the report, the cross-examination of the PW was closed and the evidence of PW was expunged and the same shall not be appreciated. My lord, in between that, what happened, my lord? The learned, my lord, the plaintiff disengaged the engaged counsel, my lord, in the trial court. So on 14/3, my lord, new set of counsel has been engaged. And only, my lord, what they have did, my lord, they have did only, my lord, file Hajira, not file any petition regarding that absence file. So
On
this
14/3.
on 14/3.
No, see, 14/3, the order was passed on 14/3.
My lord.
Till 14/3, there was no order for expunging your.
Yes,
So the order for recall would only be petition for recall can only be filed after 14/3, not on 14/3.
that is true, my lord. My contention is, my lord, on that day also, my lord, the engaged counsel of the plaintiff, my lord, did not inform the court that on the that day fixed for cross-examination, they somehow could not, my lord, present.
That was
Or
not
they did not
intimated.
pray for a further time.
Yes, my lord.
They could have,
Yes,
before passing the order of expunging.
yes, my lord. Yes.
They could have prayed for time to give another
Yes.
opportunity.
Because
Okay.
on that day, my lord, plaintiff engaged another set of counsel.
Okay.
Subsequently, my lord, this new set of counsel, my lord, filed an application, my lord, under section 151 of CPC, my lord, for
Page.
recall.
Page.
Page, my lord, page 33, annex of 4.
Yeah, yes. Yes.
My lord, the explanation is at page 34, my lord, para 3, my lord.
Mm. Yes.
Para 3 is there, my lord. It is stated that after filing PW, the engaged counsel tried to contact the learned commissioner over telephone, but he failed to contact and nor
Okay.
meet the
Okay.
learned.
Thereafter,
Thereafter, my lord, annex 8, my lord, page 30, page 40, my lord,
40.
40.
Yes.
So, my lord, this is the impugn order, my lord, whoever the petition
This
for report.
petition was filed when? 151 petition?
This one filed on, my lord, for this was filed.
On 6th of May
Yes, my lord.
2019.
Yes. 6th of May.
Then what happened? What order passed in page 40?
Then, my lord, page 40 is the order, my lord, against that recalling petition, my lord.
3110.
Yes, 3110.
Yes. Yes. What is the order passed?
My lord, para 3, my lord. For invoking the provision of section 150 of CPC, one must show that there is any abuse of process of the court. Here, the case is that in the default on the part of the counsel for the plaintiff in not making any contact with the commissioner, and that by itself is not abuse of the process of the court. Further, that for appearance of the witness are fixed by the court, and the parties need to adhere by such order. But in the present suit, it reveals that the plaintiff or his witness did not appear before the commissioner, and so that claim of the plaintiff is not accepted. Further, the discretion to be exercised under section 150 of CPC is not a matter of reality because a party filing any petition under
Where
the
has been
provision-
rejected?
Yes, my lord. So against these two order, my lord, this present petition has been filed. My lord, my prayer is, my lord, only for one instance, my lord, the plaintiff, my lord, has failed.
Which two orders?
My lord, this 30, 10, 90, 31, 10, 19, and my lord, for 14, 3, 19. 14, 3, 19 is the order, my lord, whereby the PW evidence has been expanded. Page 32.
When did you file this?
My lord, this matter has been filed in, my lord, 22, my lord, in the year 22. But my lord, somehow there was some defect. My lord, the plaint of this petition was not clear. So we have instructed to, my lord, bring the plaint, my lord. Plaint is, my lord, at page, as you may see. At page 18, my lord. There was some defect, my lord. That's why there's some delays in the judgment.
22, if you even got filed in 22, impugned order is of 2019.
My lord.
Are you really interested in pursuing your remedies?
My lord, now, as per my instruction, now the,
You took 2 years to rectify the defect.
my lord.
You filed the petition after 2 years. From 19 to 24, how many years? 5 years have gone past. Are you having contact with your clients or not?
No, my lord. Recently, my lord, they have given this copy, my lord. That's why we have rectified it, my lord. Now, my lord, as per my instruction, the defendant side also not appear in the trial court. Now the matter is pending in the trial court. The engaged counsel or defendant also withdraw their wakalat nama.
It will not make any difference if
Right.
you do not establish your case by adducing evidence.
lord.
It is not on the basis of the plaint.
My lord.
At least somebody has to stand
Yes,
on the witness box and say, verify the statements.
my lord.
Even if you do not exhibit any documents or anything else, at least you have to make a statement on oath.
Yes, my lord.
What purpose will it serve? Defendants are not appearing. Here notices will remain unserved.
My lord, now as per my, the matter has been fixed for, my lord, PW has been closed because they are not appearing. And matter has been fixed for argument, my lord. Only my prayer is, my lord, if this PW has not been considered, my lord, this matter may be in fact first, my lord. The suit of the plaintiff may be in fact first.
The suit will go now. PW has been closed. It was closed in 19. You filed in 2022. You had a new set of counsel who had appeared on 19. 14/3 March.
My lord.
Suit was for suit at right and interest.
Yes, my lord.
What was
And-
the suit property?
My lord, suit property is, my lord, first you may kindly see at page 27, my lord.
Even if you file it under 227, it has to be treated as a revision petition. There will no limitation will come in.
No, my lord.
Hmm? Can powers of 227 can be exercised by wholly ignoring the aspect of laches, at least, if limitation no. Laches is still there. Heard Sri K. Sinha, learned counsel for the petitioners who by means of this application filed under Article 227 of the Constitution of India has put to challenge order dated 14/3/2019 and 31/10/2019 passed by the learned civil judge number 1 Kamrup M in TS number 8 of 2016, full stop. By the first order, comma, the evidence of the petitioners who were the plaintiff in the suit has been expunged due to their non-appearance, and by the second order dated 31/10/2019, the prayer for recall of the aforesaid order dated 14/3/2019 has been rejected. Full stop, para. It however appears that the present petition was filed on 22nd of June 2022, and when it is found that there were defects, full stop. The defects have been rectified recently, whereafter the case was reported on 7/6/2024, full stop. Para. Let notice be issued, returnable on July 17th, 2024. Let steps be taken for service of notice upon the respondent by registered post with AD steps within 3 working days. Para. The maintainability of this petition on the ground of delay and laches is however kept open. Okay, right. We'll take a break of 5 minutes.
In a probate title suit. Page 70, your lordship.
FAO,
FPO, your lordship.
appellant is the defendant.
I'm the defendant, your lordship.
How many, one appellant?
Oh, there is, I'm the appellant, your lordship.
Defendant number,
I'm the defendant number 3
suit
in the
for,
original suit. Your lordship, a probate case, your lordship.
suit for grant of probate.
Probate, your lord. The suit was filed, your lordship, may
Hmm.
kindly peruse page 19.
Yes, tell us
Which
what has
case?
happened. Tell us what has happened briefly.
Your lordship, the miscase was preferred, the probate miscase was preferred on 31/3/2021. The mother who had expired on 22/2/2018. So
22
to
to
2018,
18, mother expired.
mother expired.
She had a will.
She had the will, and the probate case, misprobate case was filed
Hmm.
on 31.
3/2021. We have recorded.
2021,
Yes. What has
So
happened
there
there?
was a delay of 37 days. It ought to have been filed within 3 years, your lordship. There was no delay condemnation petition. Report.
No delay condemnation
No,
petition
no.
means it is a petition. Is it a petition or
Yes,
is
your lordship, it has to be, there has to be a petition, because there was a delay.
no? Is it a suit or is it a petition? It's a suit.
It's a suit. At first, it was a miscase, your lordship. Later, it was converted into a suit. Probate
No.
title suit.
Is there a provision for condemnation of delay in a suit?
Yes, your lord. Yes. There is a judgment also, your lord. 2014. 2011.
Oh, you have
1
just
Court Secretary.
Kamekha Prasad.
Kamekha Prasad.
Oh, it has been held to be an application. That is what we are asking you.
Yes.
Is it an application or is it a plaint? It's a suit.
It's
not
a
a
suit.
suit,
Subsequently,
Suit.
it was converted into a suit, your lord.
but it's an application.
Yes.
So section 5 will apply.
Yes.
So
there
what was the asset condition? So subsequent, what was the, there's
So
the order?
then your lordship was the said application, they had filed a miscase on the same date, that is on 31/3/2024.
Which-
51,
Which date?
on the same date, your lordship,
No, 31/3/2021. You said that you had filed the suit.
and as well as a miscase, your lordship, page 51.
Miscase for
Or there should not be any construction in the suit property.
injunction.
Injunction, yeah. And that was disposed of on, your lordship may kindly peruse.
Injunction in a probate case.
Yes, your lordship. Page 70, 26/2/2024.
Hmm?
It was disposed of on 26/2/2024, your lord.
26,
2024.
page
Page 70, your lord.
17.
70.
70.
70.
Okay,
May I read page 78? your
just a
lordship?
minute, please. Yes, page 70. Yes. This Mijay case 29 is for injunction.
Yes, your lordship. After a period of 4 years, your lordship, an order was passed.
Yes.
May I read page 78, your lordship? on this?
Now, what is your grievance now before this appellate
They
court?
ought to have filed a petition, your lordship, condemnation petition. May I read just page 78, your lordship, make very clear. Page 78 for a moment.
78.
78. Learned counsel had a lordship.
Yes.
Learned counsel for the opposite party number 3 objected the prayer of the injunction on the ground that all the legal heirs of the testator got their respective share of land, and he was stated construction over his share of land only. He was further submitted that the testator died on 22/2018, whereas the probate case has been filed on 31/3/2021, that is beyond 3 years from the date of expiry of the testator, but no petition for condemnation of delay has been filed. As such, the probate proceeding is not maintainable, and on that count, the present petition is not maintainable, and it reserves outright rejection. It is further argued that if there is any ingredient, the petitioner could have approached the competent civil court, but the petitioner did not approach the competent civil court, rather filed the instant petition only to harass the opposite party number 3. The fact whatever has been alleged by the petitioner totally false and baseless, and the case is filed only to harass him. There is no prima facie case in favor of the petitioner. The balance of convenience is in favor, and he would suffer irreparable loss and injury if injunction is granted. Hence, this waits for dismissal of the prayer of the petitioner. he has submitted that although the probate case started the character of civil suit, but is first and not a civil suit, and as such probate court has no jurisdiction to grant injunction in support of submission. He has relied upon the following reason. I relied on Kamakhya Prasad, Your Lordship. Learned counsel for the petitioner replying on the argument advanced by the learned engaged counsel for the opposite, but has submitted that the probate petition has been along with an application under Section 5 of the Limitation Act, and even if it is assumed that the probate petition has not been filed along with the petition under Section 5 of the Limitation Act, the same can be filed subsequently, and for a mere technicalist, one cannot be deprived of his legitimate right. Now, Your Lordship, Kamakhya Prasad has made it absolutely clear that it ought to be filed. Your Lordship may kindly peruse the paragraph 48. May I read 48?
Yes.
Thus, though as a matter of law, the right to apply for granting of probate or letter of invitation occurs on the death of the testator, and as such an application has to be made within 3 years from the date of the death of the testator. Yet, such an application is made beyond the prescribed period of 3 years. An application under Section 5 of the Limitation Act has to be made showing sufficient cause for not applying the probate or letter of
No,
administration.
Mr. Devi, that will go to the root of the case.
Yes, sir.
You are before us again grant of injunction.
That is what, Your Lordship, because the main suit doesn't, because the main suit, Your Lordship, there is no condemnation petition, Your Lordship. The main suit doesn't arise.
Now, where is your defense to that in the written statement? This is, we are only considering the correctness of an order passed in an injunction
Yes, Your Lordship.
application.
Yes, Your Lordship. And that is where, Your Lordship, it has been very clearly stated by the court. The court has discussed Kamakhya Prasad, Your Lordship, but the court has stated it can be filed later on. My respectful submission, Your Lordship, is that it has to be filed along with the suit. The condemnation petition has to be filed along. That is what.
Oh,
Kamakhya
has
Prasad-
it been filed?
No, Your Lordship, it has not been filed. The plaintiffs have not filed the condemnation petition.
But
That
that
is
will
my-
that is on the maintainability ground. We are deciding, we are here required to see the correctness of the order passed in the injunction application.
Exactly, Your Lordship. Then, Your Lordship, may kindly peruse a missed case. I have filed a missed case, Your Lordship.
For
Missed case, Your Lordship, for an injunction. Lordship, may kindly peruse.
injunction,
IA, Your Lordship. I have filed an IA.
IA for what?
IA for injunction, Your Lordship.
Injunction has been granted.
Lordship, may kindly see page 9.
IA for what?
And-
Injunction,
Yes, Your Lord. No order for injunction. In this case, Your Lordship.
injunction,
Yes, Your Lord.
what injunction?
Order 39, Rule 1, Your Lordship.
Order 39 Rule 1.
Lordship, may kindly peruse page 9 for it.
Yes, see the cost title. Cost title of the IA.
41 Rule 5.
It's a petition for stay, not for injunction. And you're not supposed to pray for injunction. Injunction is already there. At best, you'll be praying for stay. There is no wrong in this
No.
provision.
Yes, sir. That is the fact.
But how, tell us, show us any law that as an appellate court, we can interfere with matters of grant or non-grant of injunction in a routine manner.
You know what? My respectful submission will Lordship, may kindly peruse the paragraph, page 9 for a moment, Your Lord. Page 9.
Of
Of
IA.
IA, Your Lord.
Yes.
May I read, Your Lordship?
Yes.
As per order dated 1/6/2019, passed by the Circle of State Connection Mutation Case being numbered as so and so. On the basis of inheritance, the name of Joseph Lawrence Anthony, Rita Jordan Anthony, James Henry Anthony, and Mary Florence Anthony is mutated in place of Rita Lily Anthony in the plot of land bearing tag number 7.
Yes.
So this was done after the death, Your Lordship, prior to the filing of the application. Then Your Lordship may kindly peruse the in page 11. This is the building permission which was granted to me.
We are not on that.
Yeah,
Because They already
exactly.
address this court on why the order of grant of injunction is bad or needs to be interfered with.
In my respectful submission, Your Lordship, the case was filed on 31/3/2021. The
That-
order was passed on
26 to 2024.
2024, Your
After
Lordship.
hearing
They had
the all
not considered-
parties.
They had not, yes, Your Lordship, they had not considered the aspect that the petitioner knew, the petitioner in the missed case, Your Lordship, then he knew that the property is already mutated in the name, Your Lordship. He knew about it, Your Lordship.
What is the role of an appellate court in a matter pertaining to injunction? Grant or not grant of injunction?
I'm praying that a order may be stayed at this place. my lord.
What is the role? How much can we interfere? Where is Wonder versus Entox? Where is Ramdev food? What does Wonder on Entox say?
I
Go
know.
slow. Appellate court has to go slow. These are matters of exercise of discretion. Unless you can show that such exercise is done, which is prima facie against the law or against the materials on record, there is a discussion of the materials. On the correctness, we may not interfere.
Yes.
It has to be a prima facie case.
I'm also
And
relying
it's
on,
only an injunction. You have not suffered any prejudice as such. You have all the rights to contest in the suit which you are doing. Contest it.
your lordship may kindly peruse this judgment also,
Name.
Bombay judgment, your lordship.
Name.
Year 2007, Bombay.
Bombay. Regarding what?
This is with respect to the will or petition. May kindly.
We are not on the subject matter of will. We are on the subject of injunction.
That is what your lordship, only injunction. part.
Yes, please. Which?
Para 12, your lordship.
Hmm.
It is thus clear that in a petition for probate or of a will or a petition of grant of letters of administration, the sole question that arises for consideration is whether or not the will is genuine or not. The property left behind by the deceased is not-
Paragraph
paragraph 12 here.
12. Yes, please. read.
It is thus clear that in a petition for probate or a will or a petition for grant of letters of administration, the sole question that arises for consideration is whether or not the will is genuine or not. The property left behind by the deceased is not the subject matter of decision of the probate court. This observation made by the division bench of the Patna High Court while considering the question whether a caveat filed by the person who dispute title of the register to the property is maintainable or not, and the division bench has held that the caveat filed by the such person is not maintainable. The Supreme Court has referred to the decision of Patna High Court in Kasinath Singh case AR 1941 Patna 475. And in the case of Sarda Jizet Mehta and Sarda Jizet Mehta and others, they had written for Supreme Court 1238 is paragraph 5 and 6 of section, those paragraph 5 and 6 stated under your lordship. I'm not reading it. Then also may kindly peruse to paragraph 13,
1-3.
13, 1 period.
Yes, please.
It is thus clear that the Supreme Court has held that the proposition of law which is laid down by the division bench of the Patna High Court in its judgment in Kasinath Singh case is undisputable. The Supreme Court has also observed that the testamentary court has no jurisdiction to go to the question of title of the deceased the property mentioned in the will. It is thus clear that in testamentary suit the property which is mentioned in the will of property which may be or may not be left behind by the deceased is not the subject matter of the testamentary suit, and therefore, in my opinion, in exercise of its power under civil procedure code, this court would not be entitled to make an interim order in relation to protection of the property unless an order is required to be made in the court in particular circumstances. In my respectful submission, your lordship, the court has not-
Difficult. Difficult. What is the nature of the injunction?
not to do construction, your lord.
So what prejudice are you suffering?
I have been constructing, your lord.
No,
If I'm-
this suit property is protected. Tomorrow, if you are successful in your defense, that the will cannot be probated, or you have raised any issue regarding the genuineness of the will. It's a stage of will, it has to be probated, then it can be put for execution. Third,
Yeah.
Sri T. Dewey, Learned Counsel, for the appellant who has preferred this first appeal against an order dated 26/2/2024 passed in J case number so and so. J case number 29 of 2024 arising out of probate title suit number 14 of 2022 by the learned additional district judge number 1 Kamrup Metro. Full stop by the said order. Please have your seat, Mr. Dewey. Comma. The learned court has passed an order of injunction restraining the petitioner, restraining the defendant, petitioner defendant, appellant defendant to interfere with the possession or make any construction of on the over the land of common area and other areas mentioned in the will, W capital, full stop, para. It appears that the suit was instituted in the year 2022.
2021, the missed case was there. 2022, the suit was turned into a title suit paper because we filed a written statement, written objection.
It appears that that originally, comma, an application for grant of probate was filed on 31/3/2021, which was subsequently and was numbered as Miss Probate case number 30 of 2021. Full stop. However, there being a contest, comma, it was converted into probate title suit number 14 of 2022. Full stop. It is submitted that the original application having been filed beyond the prescribed period of limitation, comma, the mandate of law required filing of an application for condemnation of delay, which was not done. Full stop. However, comma, without considering that aspect on the maintainability of the application at all, comma, the impugned order has been passed on 26/2/2024, granting injunction. Full stop, para. Sri Deori, the learned counsel for the petitioner, for the appellant, has strenuously argued that the order of an injunction could not have been passed in view of the fact that that there was no application filed for condemnation of delay, which is required under the law. Full stop. He has also questioned the jurisdiction of the learned court in passing orders of injunction in a probate case, which according to him is not permissible. Full stop, para. In support of his submission, comma, the learned counsel has referred to the decision of Kamakhya Prasad Gupta, so and so, reported in 2011, 1 GLT 435, wherein this court had that in a case for probate, comma, the application of the Limitation Act, including the provisions for condemnation of delay under Section 5, would be applicable. Full stop. And here the learned counsel has also referred to a case of the Honorable Bombay High Court, reported in AIR 2007 Sailabaha, Naam Didiba, wherein an observation was made that in a testamentary suit, comma, interim orders are not to be passed. Full stop, para. the exercise of discretion, the adjudication of a petition for injunction is essentially an exercise of discretion, which however is to be exercised by following the due process of law. Full stop. It is trite law that the three golden principles, namely availability of a prima facie case, comma, sufferance of irreparable loss and injury, and are to be looked into by the trial court. Full stop. The aspect of public interest is also one of the factors which is to be looked into. Full stop. Para. The exercise of discretion if done by following the prescribed procedure is not to be interfered in a routine manner by an appellate court. Full stop. The law in this field is well settled, and one may gainfully refer to the case of Wonder versus Antox, reported in so and so, wherein the following has been laid down. Full stop. In the subsequent case of Ramdev Foods, comma, the Honorable Supreme Court, while endorsing the views in Wonder Supra, has made the following observation. Full stop. Vera. This court, being an appellate court, while examining the correctness or legality of an order of grant or not grant of injunction, would only see whether such orders has been passed by consideration of the materials on record, or whether there is any perversity in the same. Full stop. This court will not make a roving inquiry into all the materials which were before the trial court, as such powers are matters of discretion to be exercised in an equitable jurisdiction. Full stop. Para. A bare perusal of the impugned order dated 26/2/2024 would show that the same has been passed by taking into consideration all the materials on record and after hearing the affected parties. Full stop. Such order being passed only as an interim measure till final adjudication of the lease between the parties, comma, this court is of the opinion that the same does not require any interference by this court. Full stop. Para. The aspect of not filing an application for condemnation of delay till now, as has been contended by the learned counsel, would be an aspect which should touch on the merits of the suit, including its maintainability, which the present appellant as defendant would be free to contest, free to urge, and accordingly the court would be under an obligation to consider the aforesaid aspect. Full stop. Appeal accordingly stands dismissed
Deputy Obliged.
in terms of the observations made above. वो decision क्या था दीदी माँ? Item 7. Seven, council. Mr. Escolita. None appears for the appellant on call. Para, in the interest of justice, list after a week.
May praise the Lord.
Yes.
Well, in this petition, the petitioner has come against the closure of his evidence, my lord, particularly by order 15 to 16.
Petitioner is the
Plaintiff, my lord, in the suit for compensation.
suit
And the-
for compensation.
Yes, my lord.
Compensation for what?
Compensation for, my lord, cutting his vehicles, my lord, against the defendants, my lord. He took a vehicle on loan, my lord. And at the instance of the officer of the state, of the concerned bank, my lord, it was put in a
Auction.
for bodybuilding and all that, my lord, in a particular garage. In that garage, my lord, the case of the plaintiff is that without any instruction from the plaintiff and without any information to him, they cut the chassis of the vehicle by 1 meter. And that made it imbalanced and it made with 2 accidents and all those, my lord. So that, and for that, my lord, he claimed compensation and damage jointly and severally against the defendant. And in that, my lord, this order was passed, my lord. There was some communication gap. That is what it is attributed to, man. And that there is a complaint also filed before the Bar Council against the council, man. With a colleague of mine, my lord, I don't want to praise so much. But then he has also expired in the meantime. For the age of justice, my lord, I pray, your lordship, the order is at page 66.
66.
Yes, yes, order is at 15 to 16, my lord.
66, you have said? 66.
66, man.
One is set of 14.
My lord.
What is the stage now?
It is pending at this, my lord. There was substitution also. In the meantime, defendant expired, one of the defendants. And he has
There is
been-
a stay order by this court.
My,
There is a stay order.
huh? Favor is there. Yes, man.
The suit has not proceeded
Not
thereafter.
proceeded, my lord, from 16, man. 4, 5, 16.
What is the impugned order?
The order is at, my lord, page 66, my lord.
Yes.
Type copy.
Yes.
Huh? Huh? 60, 60, 61.
66 or 60.
My lord, there are 2 orders in fact. 66, your lordship will come to another order. My lord, I'm just reading it out.
You're at 61 or
to-
66?
I am at 66, but that is a
Yes.
later order. My lord, it refers to the earlier order.
Earlier
Go-
order is at page 61.
Yes,
Let
ma'am.
us go chronologically then.
Yes, my lord, 61.
27, 22/7.
Yes, my lord. May I read?
Yes.
Both the sides have filed haziras. Learned advocate for the plaintiff has submitted that he is not going to withdraw his wakalatnama as because the plaintiff has contacted him in the meantime. So prior to this, my lord, he filed a withdrawal notice, my lord, for withdrawing from the case, my lord, the counsel.
Okay.
And then, my lord, this on the next date, my lord, withdraw as because the plaintiff has contacted him in the meantime. Learned advocate has paid for giving a
Okay.
short date for
Okay,
filing.
your no further time to adduce evidence of PWs. That was closed.
Yes, my lord.
PW is closed.
Yes, my lord.
You have not deposited 1,000 cost also.
Well, I was never communicated all these things, my lord. Engage advocate for plaintiff again for petition, all this, my lord.
And second order at page 66.
Yes, my lord. Then thereafter, there are other orders. And then, my lord, finally,
15 to 16.
at page 66, my lord, 15 to 16. Both sides represent a counterclaimants have not filed evidence in the suit. Plaintiff has filed petition seeking more time till he obtains the certified copy of MBI report. This was an issue, my lord. But there was a complaint case also. No, there was a police case, one other, my lord, in which connection, my lord, this MBI
But
report.
did you file any application for recall of 22/7? You did not file any application.
No, man.
If 22/7 is not recalled, then
Well-
where is the scope of allowing you to adduce evidence? Mr.
so-
Sattar, what do you say?
My lord,
We
Yeah,
are
I
not
think-
with Mr. Goswami, but for the end of justice, if you say something, then
that the justice will do justice, my lord. But
No,
the
what-
fact remains that since the year 2011, my lord, they are taking time to file the PW. And ultimately.
no,
it was closed.
no. Normally, we would have not even sought your response. We would have straight away done. But here, some advocate passed away. There was communication gap on those consideration.
In this case, both the orders have been challenged.
No,
For
not
20
in this case, but before you could take out any plea for MVI report,
Well-
all those, unless you make an application for recall of 22/7.
I don't know if your
Report
lordship,
will-
my lord, goes to the order sheet, my lord. Your lordship will kindly see, my lord, they entertain this, my lord. I can speak only from the records, my lord, whatever I have, my lord. After the 22/7, my lord, there are a number of orders that have been passed,
No, Mr. Goswami,
my lord,
the closure of PWs does not make it the end of the suit.
my lord.
So suit was continuing.
Yes.
The aspect is only for closure of your evidence. Now that closure was made on 22/7/2015. There is no application for recall of that order.
Well, if your lordship comes to the order dated, my lord, 13/11/15, 16/12/15, these are all fixed for evidence of PWs, my lord.
But after all these years, do you have evidence?
My lord. I do have, my lord, my eyes, I suffered substantially in terms of money, my lord.
No, that is okay. Do you have the evidence? If we allow, suppose we allow this petition, are we in a position to?
Yes, my lord, yes.
We have serious doubts.
My lord, documents are there, my lord. The MBI report is there, which I have annexed here. Your lordship will kindly see. Kindly come, my lord. This, your lordship has just seen the mention of that.
Suit is of
Okay.
the year 2010.
Just for once, my lord.
Suit is of the year 2010. Till
page-
2015, you have not been able to.
My lord, page 20, let me kindly be
Page
seen.
20.
Page 28, my lord. After we got the report, my lord, copy, my lord. This is
28 is
page
2007. 2007.
page 28, my lord.
Yes,
07, my lord, where it is stated, this is a report from the motor vehicle inspector, man. At serial 10, your lordship will kindly see 2 numbers of cut piece of chassis frame of 3 feet 5.2 inch or 1 meter 5 centimeter in length were found in the luggage van.
No, that is okay, but this was in 2007.
My
The
lord,
closure is of 2015.
my lord,
After 8 years.
that recovery tribunal, that matter was going on, my lord. So therefore, and that was settled, my lord, which I have mentioned, my lord, I believe.
May not be a fit case. Let there be an end today. Suit of 2010.
I stand to lose substantially, man.
How much? What was your claim?
31 lakh something. That the money that I had to pay to the bank.
What was the cost of the vehicle?
That is what it came to, my lord, in the ultimately DRT, my lord, proceeding. That was the settled amount, and that was that money I had paid.
DRT means you had taken a loan
I
for
had
the
taken,
vehicle.
I had taken loan from the state.
Then you did
Then,
not.
my lord, that was body was.
You did not repair
made
the-
2 accidents, my lord, because the chassis were cut down, my lord, and that became, my lord, balance was lost, my lord, that vehicle. And
What
it
happened
used
to
to
the
run in
road?
the Shillong route.
Why was the DRT proceeding instituted? You had,
There was a default in payment of the. Since the vehicle was lying in the garage, man, same garage where. Your lordship may also put down some specification, some period, my lord, like that also, it can be brought to a close, my lord, in an early.
from 15 to 2000, 2010 to 15, 5 years.
I'm sure, my lord, my client will change the lawyer, my lord, down there. It's not me, man.
What happened to the certificate, DRT certificate?
DRT certificate, man.
That is not connected to
No,
this.
no, that money is given, I had to give, man, payback, man. I have paid this. Thereafter, I filed this suit, man, claiming the compensation.
I heard Sri B.D. Goswami, learned counsel for the petitioner. Also heard Sri Sattar for,
I am for the respondent, respondent, my lord.
Sri
Respondent
Sattar,
number 1, my lord.
the learned counsel for the sole respondent.
No, not sole respondent,
Yeah,
respondent number one.
For the respondent number 1,
Yes, and.
whereas Sri A. Parviz appears for the respondent number 2, who was subsequently impleaded in this proceeding. Full stop para. The petitioner has put to challenge orders dated 22/7/2015 and 15/2/2016 passed by the learned civil judge number 2, Kamrup, full stop, by the first order, comma, the learned court had closed the PWs, full stop, by the second order dated 15/2/2016, comma, the earlier order was reiterated and reiterated, full stop para. Sri Goswami, the learned counsel for the petitioner, has submitted that the suit was instituted in the year 2010 for recovery of money, full stop. It is submitted that because of wrongdoings by the respondent number 1 as the tortfeasor, comma, the petitioner plaintiff had suffered loss, and in fact, a proceeding was also instituted against him in the learned DRT Guwahati, wherein, comma, a substantial amount was required to be paid by him in terms of the certificate issued, full stop, para. It is submitted that it is because of the action of the respondent number 1 in damaging the vehicle in question, whereby an allegation has been made that the chassis, CHASSIS, was cut and reduced, whereby the entire balance of the vehicle was affected, leading to causing of accident, full stop, para. The learned counsel has also submitted that there was communication gap of the petitioner with his counsel, which had led to the aforesaid situation.
My
Full
lord,
stop.
he also filed a complaint, my lord, that is in the additional affidavit,
full
my lord,
stop,
in the bar counsel.
situation. And in this regard,
Well-
comma, he had filed a complaint before the bar council, full stop, para. Per contra, comma, Sri Sattar.
And my lord, just one second, during the pendency of the complaint, my lord, he had
Oh,
filed.
Sri Goswami has also informed that the concerned counsel has passed away in the meantime. Para. Per contra, comma, Sri Sattar, the learned counsel for the respondent number 1 has submitted that the orders impugned have been passed by the learned court by taking into consideration all the material facts and circumstances. And there is no perversity in the said orders, full stop. It is submitted that unless any perversity or gross illegality is able to be demonstrated, comma, this court may not exercise the supervisory jurisdiction under Article 227 of the Constitution of India to interfere with such orders. Full stop. Para. Sri, anything, Mr. Parvez? Sri Parvez, the learned.
Actually, we have finance debt.
The learned counsel for respondent number 2 has, however, submitted
We have finance
that-
debt and DRT case.
that he would not have any major role in the adjudication, as it was his client who had given the loan and was subsequently recovered through the DRT. Full stop. Para. The para. A perusal of the first order dated 22/7/2015 would show that the scope to adduce PWs was closed. Full stop. The learned court has, however, recorded that for the last 4 years since passing of the order, before passing of the order, comma, the case was at the stage of filing of evidence by the PWs. Full stop. Para. The court, the court has also recorded that vide an earlier order dated 29/4/2015, a cost of rupees 1,000 was imposed, which was also not deposited. Full stop. Taking into consideration all the aforesaid facts, comma, the order was passed. Full stop. Para. In the subsequent order dated 15/2/2016, comma, the court was considering a petition by which further time was sought for to obtain certified copy of an MVI report dated 16/1/2007. Full stop. This court, the learned court had, however, observed that vide the earlier order dated 22/7/2015, comma, it was already directed that no further opportunity would be given to the for adducing PWs. Full stop. Para. It transpires that against the order dated against the initial order dated 22/7/2015, no application for recall was filed, and therefore the subsequent order dated 15/2/2016 cannot be found fault with. Full stop. Para. This court has also noticed that the suit is of the year 2010, was instituted in the year 2010, and as recorded by the learned court, comma, till a period of 4 years, comma, the evidence of PWs were not filed. Full stop. Though there may be some substance in the submission that there was a communication gap of the petitioner with his counsel, comma, such communication gap cannot be stretched to a period of 4 years, which itself shows lack of bona fide on the part of the petitioner to pursue the case. Full stop, para. The power to be exercised by this court under Article 227 is a power of supervision and to ensure that the courts below act within the ambit of law. Full stop. The impugned orders do not reflect that there has been any error in exercise of powers either from the point of jurisdiction or from the point of consideration of the relevant materials which was before the court. Full stop. The court, this court is accordingly of the considered view that no case for interference is made out. Full stop. Petition is accordingly dismissed. Yes. Today we'll continue till 2 o'clock. After 2, we'll not be able to sit. We have.
Mark.
47.
Yes, Mr. Decker.
Here petitioner has challenged the order dated 31/2023, Annexure 6, whereby the applications filed by the petitioner for amendment of the pleading
This is
As
item
a part-
number,
47.
it's for admission.
Yes, sir.
Madam, you are appearing.
Yes.
Yes, yes. We take for disposal?
Yes, sir. Small issue, Lord.
Yes.
Actually, Lordship, they already amended their plain one.
Okay.
And again, they also cannot be entitled to amend their plain effects. And Lordship, when main defendant have filed WS some counterclaim, then the land mentioned already, bearing Patta number 42 of Patsala town and Patta number.
Mr. Decker, you have filed for amendment of the plane?
Yes,
Yes.
amendment of the plain.
Before framing of it.
Okay.
That
What,
initial
But,
step.
but they failed to do so and they.
I'm stating the
have
fact.
wrote in the formal amendment. which
at
is
what
not-
stage amendment can be done?
Lordship,
At what stage amendment can be allowed?
amendment can be allowed on Lordship, they know everything about the civil.
What is the procedure? What does the law say? Where is your CPC?
This is Lordship,
What is the provision for amendment? You have not brought the book. Take this book. Before we go to the facts, first we have to understand what is the provision of law by which if amendment can be prayed for, if prayed for, under what provision it can be allowed or considered.
yes.
Yes, what is the provision? And we should come prepared with the basics. Don't come only for the sake of. This is not very tough. You read the petition, under what provision it was filed. In one button, you get hundreds of cases. What is the stage? See, Mr. Roy, where are you here? In this court. Okay. Madam, you come prepared? Yes. Some other day. Wednesday next.
But interim to conflict.
Okay. Heard speech as declared counsel for the petitioner. Para. This is item number 47. Madam, your name is not there.
On behalf of applicant
Okay. What is your name?
and the
N. Dotto. Miss N. Dotto, learned counsel for the respondent, one respondent. Two respondents, however, pray for some accommodation, full stop, list on Wednesday next.
Interim to public.
Interim order passed till it will continue till the next day of listing.
Okay, this matter was called day before yesterday also,
Okay,
and I had shown to your lordship the order dated 2011-2023,
okay.
wherein it was admitted, notice was issued, and the records were also called. But inadvertently, the substantial question of law was not
We're
framed,
not framed.
not
Okay,
framed. So
okay.
that case, lordship.
Okay, okay.
So today I'll satisfy your lordship on the substantial question. of
Where
law.
are your
It is in
questions?
page 6.
Page 6.
Lordship, at this moment, I'm demonstrating this number 1, question number 1.
Let us have a look.
Yes.
It's a regular second appeal.
Yes.
Page 6.
Page 6.
Which one? Okay.
Roman
Whether
1.
the agreement between the plaintiff and the defendant is transferring the possessory right of the suit and clarifying the term that the defendant will execute.
In the impugn order, lordship, the
What
trial-
has been held?
the
It's a,
appeal-
it's a concurring finding.
No, it's not concurrent. It was decreed in our favor in the title suit. And thereafter, the defendant had.
Just a minute, please.
Yes,
You are what?
we are the plaintiff.
Appellant is the plaintiff.
Yes,
How many of you?
lordship, only one.
Appellant plaintiff suit for?
It was suit for a specific performance.
Okay.
And
And the
it
trial court decreed in your
Decreed,
favor.
decreed in my favor.
First appellate court had reversed the decree.
Reversed the decree, but then partly allowed, the alternative prayer was allowed.
Alternate prayer for
It was for the returning the money.
refund of the money.
Refund of the money,
Okay.
that was allowed.
You want the specific
The
performance.
specific
There is
performance.
no bar in law.
There is no bar in law. There is no bar in law because.
No,
lordship,
was any bar taken as a defense under the specific relief act? No.
They had taken a defense that during the time when the agreement was made,
Yes.
it was a government allotted land. It was an allotted land under ceiling surplus.
Okay.
So what we want to say is that, yes, it was, and the agreement was that it was a contingent contract. That once it becomes Myadi, only then a sale will be done, it will be executed.
Hmm.
So when it becomes Myadi, there cannot be. It was contingent on the fact of that. If it never became Myadi, we could have never enforced. So that aspect was not taken into consideration.
What was your case? What was the projected case?
Projected case, now admittedly, lordship,
You had an agreement
we had an agreement
with the defendant.
with the defendant.
Agreement for?
Agreement for one, the possessory right was given to us.
Okay.
Possessory right was given to us
By them.
by them immediately. And number 2, that as and when after payment of premium and everything, it will become Myadi, they will execute a registered sale. These two things. One is a future aspect.
Depending on a contingency.
On the contingency
That it
becomes Myadi.
because it was converted into a periodic.
Within
patta.
2 years, it became periodic. Patta.
Oh. Okay. Now, what was the finding of the first appellate court?
First appellate court says that because it was an allotted land and the allotted land cannot be transferred, therefore it's a void. contract.
The transfer is only on the possessory right.
Yes, so that's what it was, only on the possessory right. And secondly, we are seeking for an absolute transfer contingent on the fact it becomes Myadi.
Is there any bar in the Contract Act?
There's no bar in section 31.
So, Contract Act also. What is the finding of the appellate court?
Appellate court, lordship,
Mr. Chaudhary, you continue to be in possession.
we were dispossessed in between. We were
Okay.
dispossessed. The possession is not there, but the agreement is admitted by them.
They are also only on the law point.
Which section of the contract?
Section 31.
Yes.
We are saying that it was a contingent contract. It was not a transfer of a government allotted land, but it was a contract which says that it will be
No, you
allotted.
see, contingency, if it is such a contingency that never happens, then it cannot be enforced. You said that the contingency has happened.
Has happened.
The land was converted
Yes.
into from government land to khas land,
Yes.
to
periodic patta.
periodic patta.
Yes.
And
In
therefore,
2011.
on happening of the contingency, they were under obligation.
to, yes.
Okay. Where is the finding of the title appellate court?
Lordship, the judgment starts from page number 86.
No, the appellate court has also said something on the jurisdictional aspect.
Jurisdictional aspect, Lordship.
Now, why have you framed question number 2?
Lordship can come to page. I'm showing a few lines only.
No, why have you framed question number 2?
I'm not pressing question number 2 at present. Let it be open, Lordship. Any other question along with the first?
No, has it been held to be void?
Yes, it has been held to be void
Under?
because an allotted land cannot be transferred. Because that is what the learned appellate court has said. But
No,
we
no.
are saying we never sought to transfer a government allotted land. We sought
No,
to.
the agreement has been held to be void.
Yes.
Okay, we'll admit this.
So Lordship, up to page number 110.
Madam, your scope in addressing, in formulating questions of law, where? Under what law? We'll address after we formulate. Heard. No. Heard 3. M.K. Chaudhary, learned counsel for the appellant who has preferred this appeal under section 100 of the Code of Civil Procedure, challenging a judgment and decree dated so and so, huh? यहाँ से लिख लीजिए, post title से. The appellant was the plaintiff in the suit instituted for specific performance of a contract. Full stop. Para. It transpires that this appeal was initially it transpires that vide an order dated 2011-2023. This appeal was admitted. Full stop. However, no substantial questions of law were framed. Full stop. Consequently, this court, vide order dated 29/5/2024, had directed listing of this matter for further consideration under Order 41, Rule 11 of the CPC. Full stop. Para. The appeal, upon hearing Sri Chaudhary, the learned counsel, the appeal is admitted on the following substantial question of law. Whether the impugned judgment and decree dated so and so, passed by the so and so court, first appellate court, in holding the agreement between the parties dated 3/2/2009 as void is sustainable in law. Any other substantial question? Madam Roy, for
Number 1.
all the respondents. Ms. S. Roy, learned counsel, is present and accepts notice on behalf of all the respondents, let an extra copy of the memo of appeal along with the annexures be served upon her within 3 working days. List after, call for LCR, admit ke baad. List after 6 weeks along with report on the LCR. What is this IA?
Lordship, IA is for non-alienation, injunction on a non-alienation of the property.
We fight object.
You file objection. Issue note, has notice been issued?
Notice was issued, and that's how they have appeared.
Okay, in the IU, right? On the prayer of Ms. S. Roy, learned counsel for the opposite parties. Matter is adjourned by 6 weeks to enable filing of objection.
Obliged.
You had filed in the nature of an injunction application.
Yes.
Okay.
Otherwise, it goes without saying that any sale will be subject to.
That is there already. Let them file objection.
Obliged.
Okay, next.
Item 9.
Please, Your Lordship, Lordship, I pray for the withdrawal of the appeal, Your Honor, because I'm basically working to file the revision, Your Honor.
Appeal is not maintainable.
Appeal is not maintainable, Your Honor. 1042, Your Honor. Appeal only revision lies, Your Honor.
Your name?
SS Gupta.
Sri S.S. Gupta, learned counsel submits that there may be some error in preferring the appeal, and therefore he prays for withdrawal of the appeal with liberty to file in the procedure prescribed.
Your Honor, one more thing, Your Honor. Registry may be kindly directed to return the certified copy.
Okay, we'll do that.
And Your Honor, the competition part also from the date of.
That you'll have to file application. Well, that will be considered. The appeal is accordingly dismissed on withdrawal, full stop. The learned counsel prays for return of the certified copy to enable him to file appropriate application, full stop para, raise free to return the certified copy to the learned counsel, to the party, oblique learned counsel. Yes, next.
Item 10.
Itu বন্ধ করে দিবেন। Then yes,
Please, my lord.
yes.
My lord, we have preferred this appeal challenging the judgment and decree dated 5/10/2023 passed by the District Judge Nalbari in title appeal number 2 of 2020,
Okay.
thereby setting aside and quashing the decree passed in the suit.
You are the plaintiff.
I was the plaintiff.
Suit for
Partition.
trial court decided in your favor,
Trial court decided in my favor.
reversed by the appellate court.
Reversed by the appellate.
Yes, what are your substantial question? How do you formulate?
What happened in this suit was the appellate court came to a finding that when partition is sought for, it cannot be with regard to a particular property. It has to be with regard to the entire ancestral property.
Yes.
That is a perverse finding, Your Honor. There is a judgment passed by this honorable court.
Partition is not to include all the properties.
No. Under the Dayabaga school.
You are referring to Justice Sekia's judgment.
Yes, Your Honor.
That will not help you.
There was an observation, my lord.
That will not help you.
The judgment was clear with that regard, my lord. That partition can be allowed.
That is only how do you appreciate the law in the Mitakshara school? When does the right accrue to a person on his birth or somebody's death? That is only explained. You come under order to rule 2. How do you overcome all 2?
Yes. We consider order to rule 2.
Yes.
We made specific pleading
Yes.
that so far as the other ancestral property are concerned, our names has been mutated. There is no dispute.
No, mutation, will it give you a right, a title?
We categorically mentioned, my lord, in our pleading, that we have got no dispute
with regard to the other ancestral property
You means the joint parties.
Joint party.
Parties jointly.
jointly. Other side also admit.
No, admits it's a contested suit.
Yes, Your Honor.
Otherwise, you would not have gone to the court.
Hmm.
If there is a contested suit, if you do not include all the properties, how will the suit be maintainable?
So we did not include all the properties. because-
Your submission that the other properties are already mutated, there is no dispute, that may not be enough. Is there an admission in the written statement?
So far as the mutation party is concerned, they have also.
No, not
admitted.
mutation, regarding the title.
There is no clear denial
No.
with regard to the other properties, my
We
lord.
we are not on denial. There has to be an admission.
No clear admission, but in uncertain terms, they have admitted, my lord.
Difficult,
In uncertain terms, they have admitted.
difficult. How do you overcome 2-2? Let us see 2-2.
It
Order to rule
says-
2.
Order to rule 2,
Yes.
whole of the claim.
Yes.
Whole of the claim, Your Honor. Our claim was with regard to the subject matter of the suit only.
Subject matter of the suit. What is the meaning of whole of the claim and subject matter? Obviously, your suit will be on the subject matter of suit.
Yes, so far
But
as
in
that
a
property was
partition
concerned.
suit, if you do not include the other properties, how will the partition suit be maintainable? Can there be multiplicity tomorrow? Tomorrow somebody else come, no, there is another property. What is the objective of 2-2? So that
The
there is
whole
no
of the claim.
multiplicity, everything should be adjudicated in one go, all the parties are heard. You are not including the other properties.
My
What,
lord,
are-
One
what
one
is
thing
your
to be
name?
considered, my lord.
What is your name?
D. Goswami, my lord.
Mr. Goswami, what are your substantial question of law?
You know, whether in a suit for partition, the entire ancestral property has to be included. And whether non-including
These
of
are-
some offshoot legal here.
These
will
are,
result in the
these are,
suit
these are settled principles. How can be a fresh substantial questions of law? And what prevented you from? Was there any predicament on your part in including the other suits, other property? There was none.
Because there was also no dispute. No.
No dispute. Saying by you, it's not due. You're a contesting party in the suit. May not be a case for entertaining.
My lord, let me be given another chance. If I
Okay,
can continue.
take a chance. On the prayer of Sri D. Goswami. D. Goswami,
D. Goswami.
learned counsel for the appellant. Matter is adjourned to be listed on Wednesday next?
Yes,
Okay.
much obliged.
Seven.
Mr. Shom, what is this?
Lord, may I please, your Lord.
Yes, yes.
The appellant is the plaintiff, your Lordship.
Hmm.
Defendant, Lord. The respondent filed a suit for declaration of right, title, interest, and recovery of property.
Just a minute, please. Appellant is the defendant.
Yes, Lord.
Suit for?
Suit for right, title, declaration of right, title, interest, and recovery of possession
Right, title, interest, recovery of possession,
and permanent injunction,
and permanent injunction.
Lord.
Okay, then,
Then the suit was decreed, Lord.
so decreed,
Yes,
trial court.
by the trial court. And the appellant preferred appeal. That was dismissed.
Oh, concurrent findings.
Concurrent finding. Although Lordship concurrent finding, the suit was filed by 5 brothers,
Yes,
although there are 6 brothers. Lord.
yes.
6 brothers, that was their admitted pleading in the plaint as well as in the evidences they have
Okay.
admitted.
Okay, then,
And Lordship, suit for declaration of title, the co-owners have to be implemented, your Lord. For declaration of title, Lordship.
has the co-owner come before the court?
No, Lordship. Lordship, Calcutta High Court judgment is there, your Lordship, Manav. In a suit for
Can you take advantage of that situation?
Lordship.
They have filed a suit, you say, no, co-owner has not filed.
No, I am not on that, Lordship. My submission would be, 6 brothers were there.
Once you use the expression co-owner,
6 brothers, Lordship.
there is no, any right of yours are extinguished. You admit they are co-owners. What was the basis of their claim
Their basis, they got their suit property from their father.
from their father?
And by way of inheritance, 6 brothers' names were
And who
recorded.
are you?
As per their claim, I am permissive possessor. But my claim is that I got the property from refugee settlement, and that was admitted by them in their evidence. In their evidence, PW1, PW5.
You're granted settlement
Settlement.
over the plot of land of the father.
No, Lordship. Kindly.
Let us see, let us have a look. Which issue?
Lordship, to
What was the issue?
issues, Lordship. And Lordship, before this, they have filed earlier suit in the year 2017. In that suit, Your Lordship, kindly see page 12, Your Lordship.
12. Okay.
Yes.
Yes.
Paragraph 2.
Yes.
That the second
This
part,
is the earlier suit.
earlier suit.
Right.
Only by one of the respondents.
Yes.
In that case, paragraph 2, that the second party is well known to the first party, as in the year 1988, the father of second party, Sri Gokul Das, came to the first party's father, Sri Chittaranjan Acharya, for shelter. It is pleaded that in the year 1988, in the earlier suit, that suit was rejected, and due to non-complying of Order 7 Rule 1. That was order page 18, Your Lordship.
Page 18.
18.
Yes.
Both the sides are represented by learned counsel. The application of the plaintiff for amendment of the plaint has been rejected.
Oh,
The
yes.
plaintiff submitted the plaint without complying the provisions of Order 7, Rule 1 and 3. As such, the addresses of parties, the date of cause of action, the description of the suit length are not there in the plaint. The prayer portion of the plaint is also ambiguous. The plaintiff prayed for possession of the suit length without decree. That was dismissed, although liberty was given you. In that plaint, they have pleaded that my father.
What was the rejection was under what?
Order 7 Rule 11, 3.
711.
7, 1 and 3. Non-complying of provisions of Order 7 Rule 1 and 3. No addresses, no prayer, Lordship, no schedule land description.
Was there any application made for rejection of the plaint?
No, that there was no description for that. They have filed an application for amendment that was rejected. First line, Lordship. The application of the plaint for amendment of the plaint has been rejected by Ms. 14 of 2017. Thereafter, on the ground of non-complying of Order 7, Rule 1 and 3, their plaint was rejected.
After filing of written statement?
Yes, Your Lordship.
Okay.
And later on, they filed a second suit, page 19, Your Lord. Page 19, can you see, Your Lordship? Earlier suit was filed only by one Sopon Acharya.
Yes.
And the later suit filed by 5 persons.
Yes.
Four legal heirs of late Chittaranjan Acharya and one of grandson of Chittaranjan.
Yes.
In that suit, they have pleaded, Lordship. Kindly page 21,
Yes.
paragraph 4.
Mm.
That during the lifetime of Chittaranjan Acharji, in the year 1995, the defendant Gokul Das and the defendant Sri Bhogirath Das came to the house of the plaintiff.
Yes.
Earlier, they have stated that my father was there since 1988,
Yes.
and the suit was filed in the year 2018.
Yes.
Limitation will also apply, Your Lordship, come into play.
Have you exhibited the earlier documents?
I have stated in my written statement, Your Lordship.
No, did you
No, that was not done, Lord.
then
That was not.
you in your written statement you mentioned about the earlier suit?
Yes, Your Lordship. Page 32, kindly see, Lordship.
But that was only a part, was it, that was no,
My-
there was
my
no
co-
finding also.
My
Maybe you could have taken advantage. What are your substantial question?
Lordship,
Was there a specific plea of limitation taken by you?
yes, Your Lordship.
It-
Your
it-
limitation was there, Your Lordship.
Oh.
Page 31, that the suit is barred by limitation.
Was there an issue framed?
Issue in that regard, Your Lordship. Limitation issue frame, Lordship.
Did you adduce any evidence why it's barred by limitation?
Lordship, I have the plaintiff itself exhibited some documents, Your Lordship.
No,
And-
since the limitation is the defense taken by you,
Yes,
did
Your
you make any endeavor in the evidence part to show that it's barred by limitation?
Lordship, it is question of law, Lordship.
You have to state.
Limitation.
No, unless you plead, court, it's a duty of the court. If
Yes,
it's barred by
argued
limitation
before the court
expressly,
below.
then it goes.
Argued before the court below, but that was decided against me, Your Lordship. Kindly see page 44.
4-4.
44.
Yes.
Three issues were taken together.
Mm,
Issue number 3, whether the suit is barred by law of limitation,
mm.
whether the plaintiff has the right title and interest over the suit land, and whether the defendant is liable to be evicted from the suit land. Page 44,
Mm.
paragraph 7.
Mm.
The suit is for declaration of right, title, interest, has possession and permanent injunction over the suit land. After thorough reading of the plaintiff as well as the evidence.
There have been developments, Mr. Som. If you come to page 45, there were
Right.
proceedings before the Joint Secretary, Revenue, who had passed subsequent orders. Those are the subject matter of challenge.
In the exhibit, exhibit 10, Lordship, kindly see page 45. Exhibit 10, order
and-
dated 31/12/2020. In that order, it was also observed that I am possessing the suit land for.
We don't
30
find any substantial questions of law.
Lordship, kindly see, Lordship, that limitation. part-
Not impleading is not substantial questions of law. The limitation part, 2065, there has been elaborate discussion on the issue.
That suit itself, Lordship, from the pleading, Your Lordship, that I am in possession since the year 1988, and that suit has filed in the year.
Now, a suit has
2018.
been, decree has been executed.
No, Lordship, I am possessing, Lord. And their evidence part, Lordship, if your Lordship see that evidence part. Evidence,
On the enter, no.
can you see PW1, your Lordship? They have clearly stated, your Lordship. PW1,
We will, we have not very
Page
inclined
three.
in. Okay, we'll admit this on the ground of limitation only,
Lordship,
not the others.
Lord.
But no injunction, no stay. Heard. Shum, learned counsel. You are not on record, Mr. Shum?
Lordship, I am appearing on behalf of Mr. H. Chauhan.
You should be on record.
Somehow it was, Lordship.
Learned counsel for the appellant who has preferred this appeal under section 100 of the Code of Civil Procedure against Wednesday, cause that will take legit. The suit, the appellant was the defendant in the suit filed for declaration of right, title and interest, recovery of khas position and permanent injunction. Full stop. Both the courts below had decreed the suit. And the London Trial Court had decreed the suit in favor of the plaintiffs, which has been affirmed by the first appellate court. Full stop. Para. The appeal is admitted on the following substantial question of law. It occurs, सिर्फ number 3 हाँ एक ही होगा सिर्फ एक नंबर नहीं होगा फिर any other हाँ थर्ड को नंबर मत दीजिए एक ही होगा call for the LCR. Let steps be taken for service of notice upon the respondents by usual process. Steps within 3 working days. Okay. Yeah. Into okay.
I notice be issued.
You press if execution is filed, not now.
Left.
It left open. Okay.
I didn't do it.
Hey, fan कर दे एक ही इसे दे दे गरम हो जाना पड़ेगा ना. Yes, item 12.
May it be the except the applicant for the plaintiff filed a suit for specific performance of contract that was rejected by both the courts, and defendant filed his written statement praying right title interest and recovered.
Counterclaim.
Yes. We are admitting that defendant is the owner of the suit property, but defendant filed a written statement that praying for right title along with counter eviction of the plea.
Okay.
So suit dismissed, counterclaim decreed.
Okay.
Then again suit dismissed, counterclaim decreed.
Okay.
Page lordship,
You have filed a single appeal.
no lordship. 2 I have filed. 1 is maybe under defective.
Okay, this is for in
This is
context of your suit
This is against counterclaim.
against the counterclaim.
Counter.
Let both the appeal come together.
Lordship, that in that case we have filed 1 IA for additional evidence. Maybe for that there is a delay. Lordship. And
No,
in the meantime, lordship.
See, 4127 would be considered, but
Lordship.
prior to that, we can admit the appeal.
Lordship can counterclaim part, your lordship can admit, as because in this case, both the courts disbelieve my oral agreement. And I have some citations, lordship, which says that on the basis of oral agreement, also specific performance of contract can be decreed. And both the courts held that the plaintiff failed to prove his oral evidence, oral agreement. Lordship. Oral agreement, the plaintiff will prove by adducing the evidence of some person. Lordship. So PW2 was adduced.
So how do you establish an oral agreement for specific performance?
Lordship, on the basis of oral, even on oral agreement, specific performance can be granted. Lordship.
No, there is no dispute. The agreement can be oral, agreement can be written under the contract. It is not
Lordship.
necessary
I'll
that all
prove-
agreements
I'll
should be.
prove only through witness, lordship. You will testify, and PW2 stated that there is an
Where
oral-
is the substantial question?
Lordship. Page 3 here. First one in regard to oral agreement. Lordship.
Again, madam, you're addressing the court. Why do you address
Lordship.
courts?
Normally, we write like this. as
No,
because,
it's not
lordship,
normally.
The filing, lordship, lordship, says that it is defective. Other, if we do
No,
not
no,
address.
the
lordship.
filing will not say it's defective. If it says defective, you show the law.
Lordship.
You should not address the court in an appeal.
Lordship.
It's a memo. Which one?
One lordship.
Mm.
Basically, my oral agreement was not considered by both the courts.
Oh, it had held that there was no oral
Lordship,
agreement.
The plaintiff failed to prove his oral agreement. So my case is that lordship PW2 is there, and PW2 stated that there is an oral agreement between plaintiff and defendant. And
He
since then-
was cross-examined.
yes, sir.
What did he say in the cross-examination?
There was an oral agreement between plaintiff and defendant, and lordship defendant himself is saying that I approached him for sale of the property, and when I did not.
Heard Ms. R. Chaudhary, learned counsel, who has preferred this appeal under sections 100 of this subsection. The appellants were the defendants. You're the plaintiffs in a suit filed for specific performance of a contract, full stop. Though there was no dispute on the part of the plaintiff's appellant regarding the ownership of the suit property in concern,
By the rest.
there was a counterclaim by the defendants
Lord.
for declaration of right, title, and interest over the said suit property. Full stop. While the suit was dismissed and affirmed by the first appellate court, the counterclaim was allowed, which was also affirmed by the first appellate court. And it is the decision in the counterclaim which is the subject matter of challenge in this appeal, full stop. The learned counsel has informed that so far as the decision in the suit of the plaintiff, another appeal has been preferred in this court. Full stop, para. The learned counsel has submitted that the finding of both the courts in disbelieving the existence of an oral agreement is not based on materials on record. Full stop, para. Let the appeal be admitted on the following substantial question of law. एक number है सिर्फ. 1 and 2. 1 and 2. 1 and 2 होगा, 2 होगा. Any other? Call for the LCR.
There is an IA lordship as defendant. He himself admitted that I am in possession.
Let steps for service of notice upon the sole respondent be taken by registered post by usual process. Steps within 3 working days. Para, list of 6 weeks along with report on service. IA for
IA for stay of the judgment, as there is a recovery prayer by the defendant in his counterclaim. And this
execution.
is against counterclaim. Yes, lordship.
Execution started.
Yes, lordship. But execution case I have not received, lordship.
Have you stated execution started?
Lordship.
Where?
Started or not? The degree itself is for
Taking steps for it to execute by filing.
lordship, para 7.
And if execution case have been initiated, you
That
inform
specific-
us, we'll
that is
consider.
specific,
In the
lordship.
IA, you write, IA will be considered.
Lordship may issue notice along with this appeal will furnish the copy of the IA also.
Okay,
lordship.
in the IA, you write, issue notice returnable by 6 weeks. Let steps be taken for service of notice upon the respondent by usual process. Full stop. The prayer would be considered. The consideration of the prayer is deferred till appearance of the parties, till the next date.
Or if I can produce the number of the execution.
Till the next date, if any,
Execution
if
date.
any need arises.
Obliged.
Please, your lordship.
Yes.
My lord, this is the second appeal against the judgment and decree by the learned first appellate court, wherein an appeal under order 43 rule 1D filed by the defendant that has been allowed, reversing the order passed in a petition under order 9 rule 13 CP. Now, just my lord, the factual background in a snippet. The appellants as plaintiffs filed suit for declaration of right, title, interest and recovery of past possession.
Appellant is the plaintiff.
Yes.
the two appellants are the two plaintiffs in the suit.
Suit for?
Suit was filed for declaration of right title interest and recovery of past possession. Now, summons were issued to the defendants. They appeared to their counsel, and the counsels appeared on 3 dates and sought adjournment, and then he stopped appearing. Now, to substantiate that, my lord, if I may take your lordship to page 36.
Then what happened?
My lord, after that, on 5/9/2016,
5/9/16.
yes, the suit was ordered to be proceeded ex
Ex
parte
parte.
against the defendants. Now, thereafter, the suit proceeded. We adduced our evidence. On the basis of that, the suit was decreed by judgment and decree dated 20/5/2017 by the learned trial court.
20, 25?
20/5/2017. Now,
25 so decreed.
yes, the suit was decreed in our favor. And thereafter, the decree was put to execution by title execution number 8 of 2017, wherein possessory warrant was issued by the learned executing court. Now, down the line, my lord, on 11/3/2022, that is after a lapse of 5 years from the date of passing of the decree, petition under Order 9, Rule 13 CPC was filed.
11/3/22.
11/3/2022. A
For
petition
setting aside ex
for
parte.
setting aside the ex parte decree.
Okay.
We filed our objection. While order dated 2/2/2023.
When did you institute the execution? 8 of 17, 17 itself.
17 itself.
In 22, they came up for Order 9 Rule 13.
Yes, they came up in 2022 in a petition under Order 9 Rule 13.
Okay.
And while order dated 2/2/2023. That is
Yes.
at page 73, my lord.
Mm.
The learned trial court rejected their plea.
Rejected Order 9 Rule 13.
Yes.
Oh, okay.
Against that, they preferred appeal under Order 43 Rule
Okay.
1D. Now, that appeal has been allowed by setting aside the order passed by the learned trial court in the petition under Order 9 Rule 13, by setting aside the ex parte judgment and decree passed in our favor, by staying the execution case, and by directing the learned trial court to reopen the suit in its original number by allowing opportunity to the defendants to adduce their to file their written statement, and there was a direction to expedite the suit proceeding. So we are aggrieved by the judgment and decree passed by the learned first appellate court, whereby the appeal was allowed.
Understood.
And these directions have been given.
Understood.
Substantial question of law, my lord, from page 18 onwards. I am pressing questions number 2, 3, 5, 7, and 8. Question number 2, my lord, for a while, my lord.
Yes.
Whether the learned first appellate court committed illegality and misconstrued the provisions of Order 3 Rule 4 CPC in holding that the state provision casts a widened duty on the court to keep in mind while disposing a petition under Order 9 Rule 13 CPC, whether relationship between defendant and his engaged counsel existed or ceased at the time when the suit proceeded ex parte, but learned Munsif number 1 did not discharge this duty while passing the impugned order. Now, this, my lord, I am taking from a part of the impugned judgment and decree. If your lordship kindly takes page number 102 of my appeal, my lord. 102.
Order 3 Rule 4 is for appointment of pleaders. Then
Exactly,
how
my lord.
he comes out of it, how he files an application,
there is
issuing notice to the client.
Yes, there is an observation out here in regard to Order 3 Rule 4,
Yes.
where, my lord, it has been held by the learned first appellate court that it casts duty on a court deciding a petition under Order 9 Rule 13, whether the relationship between the defendant and the advocate had ceased or continued thereafter. Here is a case where the advocate appeared for 3 consecutive dates and prayed for adjournment. Thereafter, he ceased to appear without steps, and thereafter the proceeding was drawn ex parte. Now, where is the question of the interpretation of Order 3, Rule 4 vis-a-vis Order 9, Rule 13? Order 9, Rule 13 never.
Let us see order 3 rule 4.
Yes, ma'am. Your Lordship kindly sees Order 3, Rule 4.
Hmm.
No pleader, my lord, has it?
Yes, yes.
No pleader shall act for any reason in any court unless he has been appointed for the purpose by such person, by document in writing, signed by such person,
Yeah.
or by his recognized agent, or by some other person duly authorized by or under a power of attorney to make such appointment. Subsection 2, sub-rule 2.
Yes.
Every such appointment shall be filed in court and shall, for the purposes of sub-rule 1, be deemed to be in force until determined with the leave of the court by a writing signed by the client or the pleader, as the case may be, and filed in court, or until the client or the pleader dies, or until all proceedings in the suits are ended, so far as regards the client.
Correct.
Here is a case where a counsel was engaged. He filed his wakalatnama. He appeared on 3 dates and sought for adjournment for filing written statement.
What is the observation on 3, 4?
Or on that your lordship will kindly take up page 102,
102.
paragraph number 13 of the impugned judgment and decree. May I read, ma'am? Page 102.
Yes. Yes, please.
In the case at hand, as reflected in the impugned order, appellants received summons
Yes.
on 4/5/2016.
Yes.
And their learned counsel prayed for adjournment on 6/5/2016, 1/6/2016,
Hmm.
and 21/6/2016. Thereafter, on 8/7/2016, 29/7/2016, and
Okay.
5/9/2016, appellants were absent without step. So suit proceeded ex parte by order dated 5/9/2016 as the failed to appear and file written statement. The case record reveals that appellants appointed their counsel and also filed relevant wakalatnama on 1/6/2016. Impugned order is silent if leave was taken either by learned advocate for appellants or appellants themselves under Order 3, Rule 4 of CPC to discontinue the authority assigned by the appellant. Impugned
Yes,
order,
yes. Where is your substantial question?
Ma'am, page 18, number 2 on this point, my lord. Whether the learned first appellate court committed illegality and misconstrued.
We'll
the
have that as a substantial
My
question.
lord, this is one. Next, my lord, your lordship will kindly take substantial question number 3. Whether the learned first appellate court committed perversity in arriving at the findings that the respondents defendants only came to know about the
No,
passing.
this may not be.
My lord,
We'll have
then, my lord, there are 2 other. My lord, regarding page number 20, question number 7. Question number 7. Whether the learned first appellate court committed gross illegality in interpreting the provisions of Order 9, Rule 13 CPC as regards sufficient cause.
Third, Sri D. Chakraborty. Learned counsel for the appellant who has preferred this appeal under section 100 of the Code of Civil Procedure 1908 against a judgment and decree dated. Is it a decree?
Yes,
Judgment, decree, in a misappeal.
my lord, that is
Judgment and decree dated 1/4/2024. Passed by the learned civil judge, senior division, Sibsagar, in misappeal number 4 of 2023, arising out of mid-J case number, 27 of 2022, from title suit 23 of 2016, full stop para. The appellants were the plaintiffs who had instituted the suit for declaration of right, title, and interest and recovery of khas possession. Full stop. It is contended that though the defendants had appeared through their counsel on 3 dates, thereafter the counsel did not appear, and accordingly on 5/9/2016 the suit was declared ex parte. On 5/9/2016, there was an order to proceed ex parte. Full stop. Para. The suit was subsequently decreed on 25/2017, and on the same in the same year, an execution case was instituted, being execution case number 8/2017, in which possessory warrant was also issued. Full stop. Long thereafter, on 11/3/2022, the defendants had filed an application under Order 9, Rule 13, CPC, for setting aside ex-parte decree. Full stop. The learned trial court, by order dated 2/2/2023, had rejected the said application registered as Ms. J case number 9/2013. Not 13, 9 of?
By
Oh,
mistake
no,
is
no, no,
number
no, sir.
27 of
No,
2000.
no, I rejected the said application. Full stop. However, the first appellate court, by the impugned judgment, has allowed the appeal along with other reliefs. Full stop. Para. Upon hearing, the appeal is admitted on the following substantial questions of law. Page number 18, number 2. And the second one is which one?
Page 27 and 8. Sir.
No, there was other relief, not this. You had framed one more.
Question 2, question 7 and 8 at page 27 and 8.
7 will be covered by one. The burden. You have not formulated on the other reliefs granted.
My lord, in so far as the sufficient ground that is
No,
under
no,
order-
no. The learned first appellate court had also granted other reliefs, which perhaps was not within the jurisdiction. So we 7 and 8. Any other? Let steps be taken. A call for LCR. Let steps be taken for service of notice upon the respondents be taken by usual manner. Steps within 3 working days.
My lord, there is an I under order 41 rule 5, paragraph 6 is the ground, man.
I for
My lord, stay of the judgment and decree and the stay of the court proceeding.
will not stay the judgment, will stay further.
Court proceeding. Yes.
Heard Sri D. Chakraborty learned counsel for the applicant, who by means of this application has prayed for stay of the judgment and decree dated 1/4/2024, passed by the learned civil judge junior division Sipsagar in Miss Appeal. ये पहले जो लिखा था, हाँ, full stop. Para. The connected appeal has been admitted today by framing substantial questions of law. Full stop. Para. After hearing and considering the facts and circumstances, it is directed that till the disposal of the connected RSA 102 of 2024, further proceedings in title suit number
23 of
23 of 2016, which has been sought to be reopened by the impugned judgment, shall remain suspended. Okay, rest matters, we'll fix a date. On matter, Mr. Roy, will auscultation lawyer.
29.
We can take your matter.
Yes,
You've
sir.
come from far. We'll take your matter.
But this may be fixed, your lord.
Why?
After the vacation, because he is,
I have
Who is seeking time?
we are not I'm not seeking any time, your lordship,
Are you
because
seeking some time?
a date may be fixed, your lordship.
I am there, my lord. I'm here.
No, no, if you, we'll accommodate you, we'll have it today, now. Or if you want to, any other date.
I leave it
This
to him.
privilege is given to an outstation lawyer.
Yes.
It's perfectly all right, my lord. I am here.
Anything which,
No, no,
I'll
if
be
you,
here.
if you want to do it, it's first day it's come. Today is the first date or what?
no, this is the second date.
What is the stage?
My lord, basically, it's, for the condemnation of delay application.
Condemnation of delay and,
In an arbitration appeal.
yes.
Yes.
Because the case was transferred from Mizoram to the principal state. And, I have been engaged after it was transferred out here. After the case had already been dismissed.
Which matter? That pipe matter?
Yes, my lord. Johnson Eastern Park.
Should we take up this matter?
Yes, my lord. Though I remain the constant, the variables have changed. That was the other matter where my
Oh,
lord.
okay, not, okay, we can. This is not between the same party?
No, it's not.
Okay, okay. You are fighting for condemnation of delay.
Yes, sir.
How many days?
But 126 days. Sir.
Yes, what do you say?
There is, my lord, because the onus is basically, my lord, the sufficient cause as described by him is basically the fault of the registry, what they are saying. Because of late, because there is a passion to shift the blame on the registry. When there is no duty or obligation cast on the registry to notify or to intimate of the transfer, that be construed as a sufficient cause in terms of?
No, what is the cause, Mr.
The
Biswas?
cause is, your lordship. The case
126
which was-
days. 126 days.
Now, what had happened is, your lordship, the application was pending for long.
This
because
is an 37 appeal.
Yes, my lord.
Yes. It is a 34 application, a 37 application which was pending before the bench at out there, but because most of the judges were at one point.
No,
of
no, yeah, there was an award in the arbitration.
Yes.
Yes.
It was dispute between you
It
two.
was set aside by the
34
district judge.
court. 34 court set aside.
It was the
No, no,
set aside
the
against that we have come
award was in favor of whom?
before with the
You are the claimant.
Yes.
In favor of
the claimant.
claimant. 34 court
Set aside.
set
It
aside.
was set aside, and against which we had gone before we had filed the application under 37.
Appeal under 37.
Yes.
37 filed by claimant.
Yes, sir.
Where?
In the Aizol High Court.
It was in
Aizol,
Aizol.
okay, then?
Then because of the long pendency, without there being any progress in this, because of the
Whatever, then
an application was filed by the proprietor of the claimant before the Honorable Chief Justice taking a transfer of this.
Okay.
Now, a notice was sent to us by the registry of Aizol saying that we are transmitting the records from
Okay.
Aizol to the principal.
Okay.
Thereafter, there was no communication as to when the case reached the principal seat,
Okay.
and the case was again renumbered and listed before this honorable court on 3 occasions,
Oh,
showing the name of the counsels who were appearing in the
Aizol bench.
Aizol bench. And now they remained unrepresented for 3 occasions because of after the relisting and renumbering of this. And I was appearing on their behalf in a DRT case. So they asked me by an email to make an inquiry. I have narrated the fact. And after inquiry, I came to know that there was an order passed whereby the application was dismissed on ground of non-appearance.
Oh, you have filed for restoration. In filing
Restoration,
this
as well as
restoration-
there is a delay in that.
Earlier also, in 37 also there is a delay.
37, the delay was in the Aizol bench.
Aizol.
Aizol bench.
And
That
in the
is-
High Court.
That is,
Let us take it to be the High Court. In the main appeal, there was a delay which was to be considered, and in the meantime, the appeal was dismissed before even
No,
consideration.
delay application was.
Delay application. Okay.
dismissed.
In restoration of the delay application, there is also a delay.
there is a delay.
Okay. And how much is the delay in the appeal?
I think 2 or 3 days, or
2
5 days.
5 days.
That's including the benefit of the probate which they got.
That means the appeal is yet to be admitted.
Yes, ma'am.
That means the question of readmission is not coming. Order 9, that 19 is not coming.
as of-
It will come only when we consider your application. We'll consider this, Mr. Roy. We'll consider this, and you can, even the,
I can present the facts later on, your lordship, with regard to the delay part. If my
We'll
lord-
do
My only issue is, my lord, if that is to be construed as a sufficient cause, tomorrow non-intimation, because Supreme Court has clearly of late said, you can't shift the blame on the registry to make it a sufficient cause, as necessitated by or required under Rule 19 and Order 41.
No, we
or
see
Section
whether there
42.
was sufficient cause. See, the Council of Aizawl, their names are reflected. You're correct. There is lack of due diligence. Once you make an application for transfer,
Right, my lord.
duty was cast upon you to make occasional.
Absolutely, my lord.
You have not done, but
No, my lord, the notice, the intimation was given to their local council there of the transfer. I have annexed with the intimation from the registry.
okay, we'll
It
consider
was duly given.
It may not be today. We'll have it
Because it
some.
was 213 days since the transfer, 126 days only the
Okay,
delay.
on a date fixed, whenever suits you.
Whatever date is this.
If
delay.
it's a contested, then
Yeah, it's
otherwise,
constant.
no, but
Your
we are
lordship,
inclined
after-
we are inclined to condone the delay.
Either
Yes, we will hear.
after the vacation
well.
or if he is, I mean.
Whatever.
The
How
19th
we-
of July, after vacation, or on 20th of this month, your lord.
Heard.
20th
Sri
of
A.
the-
Biswas,
Or 20th, it will be difficult, so 19th of.
learned counsel for the applicant, whereas Sri A. Roy, learned counsel has appeared for the sole respondent,
Yeah.
sole respondent, who has objected to the application for condemnation of delay in filing the restoration application. Full stop para. As requested, list this case for consideration when? Tell us the date of your convenience.
And 19th, your lordship, I have.
Very well, Mr. Applicant.
19th of
July,
Friday.
Friday, yeah.
Yes, we can have 19th of July.
Very good.
19th of July.
Obliged.
Grateful, my lord.
Okay, rest of the matters, any matters where interim order is still today? We have to extend, otherwise dates court master will give.
14 meter on Wednesday, because
This Wednesday, what is the
execution is going on second.
fresh matter?
First,
Fresh matter is Roy ko nahi hai.
14.
Okay, Wednesday. Okay, we'll have.